Okay, it looks like we're streaming. Thank you.
You got it.
And who are you, Mid? Do you have all your scorers in here?
No, I'm still waiting on two. Oh, there's
Okay.
one.
Okay, we've got a few in the lounge, so
We're waiting on one score, and then we'll be ready to roll. So any participants who are not going to be testifying or examining, they should put their video on, they should stop their video.
Hi, this is Diana Fields, one of the scoring judges. Do you
Yes.
know, I had the link to the online scoring sheet and I just exited out of it. Do you happen to have the link? Does anybody have the link? Put it in chat.
I don't, and I think the best thing to do is email Laura or Kyle.
Yeah, okay. He put it in chat when I was just in the judges lounge, but then I deleted it.
I've got it pulled up on mine, so I just put
Oh,
that in
great.
there.
Thank you. Thank you.
All right, before we get started, could everybody who's hide their video or turn off their video who is not going to be a witness or, there we go, or the prosecution. All right, we are on the record, and for the prosecution, are you ready?
Yes, Your Honor, the prosecution is ready to proceed with trial.
For the defense, are you ready?
Yes, Your Honor, the defense is ready to proceed.
And assuming that the scoring judges and panelists have a copy of the rosters, everybody have both parties approved the taping of the round?
For the purposes of live stream, Your Honor, yes. However, we've not agreed on any sort of internal recording.
Okay, then there will be no internal recording unless everybody has agreed, except for live streaming. You do understand that the Colorado Bar Association may be taking photographs of the competition?
Yes, Your Honor.
Is there anybody in the gallery, and it doesn't appear that there is, who is not competing in this particular round? I don't see anybody. Is there anybody aware of somebody in the gallery who's not competing in this particular round? Nobody is answering. No recesses will be allowed except for with the exception of a health emergency, and there won't be any recesses or breaks between the end of witness examination and the beginning of closing arguments. And the score for the 3 scoring judges, now that you've reviewed who the roster is, are there any conflicts of interests that you wish to waive or raise?
None for me.
None for Ms. Landis?
You know, I apologize. I do not have the roster and I don't have the team codes. Where am I to get that?
I'm going to read you a list of names. Do you see the names on the side?
I see everybody's screen name.
Okay, and so those are the names except for the ones after the slash. Are those names that you recognize?
No, there are none. And also, just if I can have the team codes too, if you're going to introduce that at some point.
Okay, I'm going to ask Laura and Kyle to do that. I just don't have those codes.
Okay, great. No conflict. Thank you.
Judge, I'll let Kyle know because I don't have a roster either. I just got added in. So, but if we get the team codes and the rosters, I'll make sure that Diana gets that too. And I have no conflicts.
All right, thank you very much.
Yeah, and I also do not have a roster, so no one has a roster.
All right, well, hopefully there can be some emailing off to the side for that. Okay. Your compliance with the time requirements will be considered in scoring in individual performances. There is no coach or team member that is seated in the virtual courtroom that is not a part of this. I think we've verified that. I'm going to ask for the prosecution first to introduce your team members, attorneys, and witnesses.
Yes, Your Honor. Good morning, Your Honor, members of the jury. My name is Lauren Leland. Today, along with my co-counsel, we will be presenting the prosecution side of this case. Today, I will be doing the direct examination of Mr. Alex Cifuentes, the cross-examination of Ms. Avery Becker, as well as delivering the closing arguments for the prosecution.
Thank you very much. And for the defense.
Your Honor, if we may have our other team members introduce themselves as well.
Sure, go ahead.
Good morning, Your Honor, members of the jury. My name is Jonas Zaichis, and today I'll be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Taylor Perkins.
Thank you very much.
Good morning, Your Honor, members of the jury. My name is Sydney Fawn, and today I'll be conducting the opening statement, the direct examination of Kyle Kuzak, and the cross-examination of Blake Van Owen. And at this time, we ask permission for our witnesses to introduce themselves.
They may.
Good morning, Your Honor, members of the jury. My name is Miles Wright, and today I will be portraying Alex Cifuentes.
Thank you.
Good morning, Your Honor, members of the jury. My name is Sarah Banks, and I will be Detective Jordan Markowitz.
Thank you.
Good morning, Your Honor, members of the jury. My name is Chloe Arroyo, and today I will be portraying Kyle Kuzak.
All right, thank you very much. And for the defense, if you could introduce yourselves and your witnesses.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Haley Karras, and I will be conducting the direct examination of Taylor Perkins as well as the cross-examination of Kyle Kuzak.
Thank you very much.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Lily Mastrangelo, and I will be delivering the opening statement, conducting the direct examination of Professor Blake Van Owen, and conducting the cross-examination of Detective Jordan Markowitz.
Thank you very much.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Caroline Tusek, and I will be conducting the direct examination of Avery Becker, the cross-examination of Alex Cifuentes, as well as giving a closing argument. At this time, may the defense introduce their witnesses?
You may.
Thank you.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Donna Shaw, and I am Taylor Perkins.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Connor Grant, and I am Professor Blake Van Owen.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Chloe Els, and I am Avery Becker.
Thank you very, very much, members of the defense team. I am now going to swear all members in. Team members, if you could raise your right hand. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And I see many nodding heads. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Gallery members, teachers, coaches, family members, and friends, raise your right hands. Do you promise to represent yourself as a positive role model and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And I am going to assume they affirm. And scoring panelists, lastly to you, please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, rules, and procedures of this mock trial competition?
I do.
All right. And thank you to the scoring panelists. Okay, at this time, we will begin with the prosecution's opening statement to be delivered by Sydney Fawn.
Your Honor, if before we continue with opening statements, if we may raise a few pretrial matters.
Ms. Leland, go ahead.
Thank you, Your Honor. First, we would like to request that both teams put the preferred pronouns of each of their witnesses in the chat just for the sake of clarity throughout trial, as we didn't exchange rosters as we normally would.
And who's the representative for the defense?
Your Honor, that is me.
Any objection to the request?
No objection, Your Honor.
All right, then pronouns shall be posted in the roster or the Zoom side.
We would also like to draw the court's attention to Rule 7.4, which states that all witnesses shall have access to all case materials and exhibits throughout the course of trial, but may only refer to them when prompted to do so by an attorney, which just means that all witnesses will have access to all of those materials in case we need them to refer to them.
But not read from them.
Of course, Your Honor.
Any objection, Ms. Mastrangelo?
No objection, Your Honor.
Then that second motion will be granted.
We would also like to clarify that pursuant to Rule 7.4, we will be showing exhibits for the purposes of entering them through the screen share function in Zoom, but we have all agreed that that will not be presumed to be shown to the jury until after they are entered into evidence.
And what you're really requesting is that while you're seeking to admit exhibits, those won't be published to the jury until admitted.
Yes, but just that we may screen share them while we go through that process.
What's your response in the defense?
No objection, Your Honor. The defense asks for the same.
All right, then a joint motion for to post prior to publication is granted.
And finally, Your Honor, we ask that any time remaining after closing arguments for the prosecution be reserved for rebuttal.
And that will be granted without seeking a response from the defense. And keep in mind the rules that rebuttal for this competition is a rebuttal to issues raised by the defense.
Yes, Your Honor.
All right. Anything else from the prosecution?
No further housekeeping matters to attend to, Your Honor.
Anything else from the defense as far as pretrial motions in limine?
Yes, Your Honor, a few preliminary matters. Now, Your Honor, the defense asked for the same requested as the prosecution, except for the rebuttal, of course.
And all those motions are granted?
Yes, Your Honor. Your Honor, the defense also asked permission for the timekeepers to be able to communicate using the Zoom chat feature as to avoid time discrepancies.
And what is the response from the prosecution?
We have no objection to that, Your Honor. We just ask that all attorneys and witnesses also remain within the Zoom chat function and not communicate through any other means.
So what you're requesting, or what your clarification is, Ms. Leland, is that if there's any Zoom chatting regarding timing, it is public.
We have no objection to private chatting about timekeeping either, as long as it remains on the topic of timekeeping.
Okay, then it shall be, the first request from the defense is granted regarding timekeeping.
Yes, Your Honor. Your Honor, the defense also asked that the stipulated facts be constructively read into the record.
Any objection from Ms. Leland?
No, Your Honor.
The stipulated facts shall be constructively read into the record.
Yes, Your Honor. No further preliminary matters, Your Honor.
All right, thank you very much. Anything else before we proceed with opening statements?
Not for the prosecution, Your Honor.
And none for the defense, Your Honor.
All right. So, Ms. Leland, I'm sorry, Ms. Fan, opening statement.
Yes, Your Honor. The defendant, Avery Becker, was telling the truth when she wrote the following words to her teammate just hours before the death of Mackenzie Brackman. "I'm going to wait until he's at work, then break in and trash it." And these words were, in fact, the truth. Avery Becker waited until she believed Mr. Brackman was at home, broke into his house, and, surprised to find him there, engaged him in a scuffle and killed him. My name is Sydney Fawn, and along with my co-counsel, I represent the people of the state of Colorado in pursuing justice for this felony murder of Mackenzie Brackman. Mr. Brackman was sitting at his kitchen table on a Friday afternoon before heading to mock trial practice at the high school mock trial team he coached. He got a notification from his security camera that someone was on his property. And when he heard them break into his back door, he realized that there was an intruder in his home. And so he grabbed the nearest thing that he could find to defend himself, a kitchen knife, and attacked the intruder with it. The two scuffled, moving through the kitchen and the dining room, knocking things over as they went. And the perpetrator eventually got a hold of this kitchen knife and stabbed Mr. Brackman. When Mr. Brackman pulled the knife out of his own shoulder, he bled to death. The defendant, Avery Becker, is charged with second-degree burglary and first-degree felony murder in connection with this horrible tragedy. The prosecution holds the burden of proof, which means we must prove Avery Becker guilty beyond a reasonable doubt. In fulfilling this burden, the prosecution will call 3 witnesses whose testimony will establish that Avery Becker was in fact telling the truth about her plan. First, we will call Alex Cifuentes to the stand. Alex Cifuentes is a teammate of Avery Becker's on the mock trial team with their coach, Mr. Brackman. Alex will tell you about the strained relationship between Avery and the decedent. Alex will tell you that when Mr. Brackman demoted Avery on the mock trial team due to a lack of commitment, Avery retaliated by vandalizing his Porsche. And Alex will tell you that just days before his death, Mr. Brackman kicked Avery off the mock trial team. And lastly, Alex will testify to the incriminating text messages he received from Avery Becker outlining her plan to break into the home of Mr. Brackman. Second, we will call Detective Markowitz to the stand, the lead detective and cell phone expert in this case today. She will tell you that she tracked the cell phone of Avery Becker and found that in the minutes before the death of Mr. Brackman, Avery Becker's cell phone pinged to the cell tower nearest the home of Mr. Brackman. She will also show you security camera footage of Avery Becker in a Halloween mask breaking into the home of Mackenzie Brackman. And last and third, we will call Kyle Kuzak, a crime scene reconstruction expert, who will tell you about the physical evidence she examined, including a bloody knife, a broken plate, blood splatter, and the nature of the fatal wounds sustained by Mr. Brackman. She will testify to her conclusion that this murder was the result of a burglary gone wrong, a burglary that Avery Becker told the truth about planning. And these 3 witnesses will establish what happened on the day of March 6th. Avery Becker, upset about being kicked off the mock trial team, decided to do something about it. She texted her friend Alex, "I'm going to wait until Mr. Brackman is at work, then break in and trash his house. That'll show him." And she did show him. She skipped school, bought a Halloween mask, and broke into his home. Surprised to find him still at home, she engaged him in a struggle and the 2 fought. This childish burglary gone horribly wrong, and Mr. Brackman paid with his life. At the close of this trial, my co-counsel will rise and ask that you determine a verdict on the charges of second-degree burglary and first-degree felony murder. At the close of this case, we will ask that you simply find Avery Becker was telling the truth when she wrote that she was going to break into Mr. Brackman's home and trash it. And we ask that you find Avery Becker guilty.
Thank you, Ms. Fawn. Does the defense wish to make an opening statement now or reserve their opening statement?
Your Honor, the defense would like to proceed with its opening statement.
Ms. Mastrangelo?
May it please the court? Good morning, Your Honor, members of the jury, opposing counsel. My name is Lily Mastrangelo, and along with my co-counsel, Haley Karras and Caroline Tusak, we represent the defendant, Ms. Avery Becker. This is a case about carelessness and convenience that led to an erroneous conclusion. Now, the prosecution has made a dangerous conclusion as to who caused Mackenzie Brackman's death. Throughout this trial, you'll learn how the prosecution failed to follow a clear lead and failed to confirm Ms. Becker's solid alibi. The prosecution willingly overlooked evidence and alternate suspects for the sake of convenience. The prosecution only gathered enough evidence to make a quick and easy conclusion, but that conclusion doesn't make sense. The tunnel vision of the prosecution led them to a convenient conclusion rather than a correct one. What the evidence in this case will make abundantly clear is that Ms. Becker couldn't have possibly committed the alleged crimes. And what the lack of evidence in this case will show is that careless investigations lead to incorrect conclusions. Members of the jury, that is why the wrong person is sitting here on trial today and why the prosecution won't prove their burden beyond a reasonable doubt. First, you'll hear from Ms. Taylor Perkins, who is Ms. Becker's best friend. Ms. Perkins will tell you about her experience with the mock trial team and the relationship she observed between Mr. Brackman and Ms. Becker. Ms. Perkins will tell you how fractures in this relationship led to Ms. Becker being kicked off the mock trial team. Ms. Perkins will then tell you about March 5th, in which she and Ms. Becker went to the Fry Shack and then spent time at the mall after. And on the morning of March 6th, Ms. Becker realized she had lost her phone, and the two decided to spend the rest of their day looking for that phone. But that phone was never found. Thus, Ms. Becker couldn't have possibly committed the alleged crime, as she was on the other side of town with Ms. Perkins the entire day. Next, Professor Blake Van Owen will testify, an expert witness and private investigator. Professor Van Owen will take you through his evaluation of the investigation conducted by the prosecution. Professor Van Owen will tell you that Detective Markowitz's investigation of the crime scene was rushed, sloppy, and was blinded by tunnel vision. Professor Van Owen will tell you about the three main issues he found in the prosecution's investigation. In his expert opinion, those three main issues are the uncertainty of the proclaimed stabbing method, the inaccuracy of the prosecution's cell tower diagrams, and three, that overall the prosecution's investigation was methodologically unsound. Professor Van Owen will show you how the carelessness of the prosecution led them to a convenient conclusion rather than an accurate one. And finally, Ms. Avery Becker will testify, who will tell you that she shouldn't even be here. Ms. Becker will tell you about her experience with the mock trial team and her relationship with Mr. Brackman. With this, she'll tell you that their relationship had its difficulties. Ms. Becker will tell you about a prior incident with Mr. Brackman's car, and then she'll tell you about her regret and the lengths she went to make amends with Mr. Brackman. Ms. Becker will then tell you about March 5th, in which she went to the Fry Shack in the mall with Ms. Perkins, and how she had lost her phone that day and didn't even realize it until the next. And on March 6th, she and Ms. Perkins spent the entire day retracing their steps to find that lost phone. And finally, Ms. Becker will tell you that she could never and she would never harm Mr. Brackman. At the end of this trial, it'll be apparent that the prosecution did not meet their burden of proof beyond a reasonable doubt. The prosecution's investigation was sloppy, careless, and led to an erroneous conclusion. Members of the jury, don't let the prosecution's desire for convenience and their utter disregard for accuracy put an innocent young woman in jail. At the end of this trial, when the prosecution fails to prove both of their claims, that the defense will ask you to find Ms. Becker not guilty. Thank you.
Thank you, Ms. Mastrangelo. It looks like Ms. Leland, are you ready with your first witness?
Yes, Your Honor. The prosecution calls Mr. Alex Cifuentes to the stand.
Mr. Cifuentes, you've been sworn to tell the truth. And Ms. Leland, your witness.
Yes, Your Honor. Hello, Mr. Cifuentes. Can you please introduce yourself to the jury?
Hello, my name is Alex Cifuentes.
How are you involved in today's case?
I'm involved in today's case because I knew the defendant, Avery Becker, as well as the victim, Mr. Brackman.
Starting with Mr. Brackman, how did you know Mr. Brackman?
Mr. Brackman was my beloved mock trial coach for 3 years, and he was a real mentor and inspiration in my life for those 3 years on the Colorado High School mock trial team.
And how did you know Ms. Becker?
Avery Becker was actually the person who urged me to join the mock trial team in the first place, and we were great friends for all the years we did it together.
What did being on this mock trial team involve?
Well, mock trial is an activity where the team is given a case and we prepare that case for trial. So we spent lots of time together getting ready for competitions and did really well. And I really learned to love the team and Mr. Brackman.
I'd like to talk a little bit about the relationship between the defendant and Mr. Brackman. Did the defendant and Mr. Brackman know each other?
Yes, Avery was on the mock trial team with Mr. Brackman for 4 years.
What did you observe about the relationship between them?
Well, given how much time we spent together as a team, I saw Avery and Mr. Brackman interact quite a bit, and their relationship was incredibly tense and strained. I would go so far as to say they had a bad relationship.
What made you think that their relationship was so bad?
Well, first of all, they were just constantly arguing and fighting almost every practice about Mr. Brackman's expectations and Avery's lack of preparedness. And, this really blew up when once Avery was demoted from the A team to the B team.
Did anything else ever happen?
Yes.
Objection, Your Honor, vague.
What's your response?
Your Honor, within this line of questioning, we're clearly talking about the relationship between the defendant and Mr. Brackman in this case, and I'm asking a follow-up question as to what sort of interactions the two of those people had.
Given that response, I'm going to overrule the objection.
So what else did you observe between the two of them?
Well, the second time their tense relationship really blew up was following the regional tournament. Mr. Brackman, after Avery's performance, was just going off on Avery about how angry and upset he was. And Avery got heated. She ran outside and wrote in permanent marker, "Worst Attorney Award," over the hood of Mr. Brackman's car.
Did you talk to the defendant after that happened?
I did. After that event.
Objection, Your Honor, hearsay.
And what's your response to the hearsay objection?
There's no statement being offered at this time, Your Honor. This is merely a foundational question for whether or not there was a conversation.
Well, I'm going to overrule the objection, but I'm going to note that the witness was about to respond with a hearsay statement. So, Mr. Cifuentes, you can't testify to what other people say. Mr. Leland, why don't you ask your question?
So did you talk to the defendant?
I did. After Avery vandalized the car, she was kicked off the team for good. So she reached out to me over text asking for help to get back on the team, which I agreed to do.
And what did she say to you?
Objection, Your Honor, facts not in evidence. The opposing counsel can explain that there was a text conversation, but not the contents of the text conversation without admitting this exhibit into evidence.
What's your response to the objection of facts not in evidence?
Your Honor, the question is to enter the facts into evidence before the evidence has been entered into, and before any evidence has been entered into evidence. It's obviously not been entered into evidence yet. So this is merely asking in order to enter that evidence into.
And on those grounds, the objection is overruled. Go ahead with your question.
So what did the defendant say to you?
After I agreed that I would help Avery, she told me that she was planning
Objection, Your Honor, hearsay.
Now what's your response to a hearsay?
Your Honor, this is not hearsay as under 801D2. It's an omission by a party opponent.
Overruled.
So what did Ms. Becker say?
Avery told me she was planning on going to Mr. Brackman's house while he was at work.
Did she say anything else?
Yes. She told me she was planning on breaking in and trashing it to show Mr. Brackman.
And was there anything else?
No.
I'm now directing opposing counsel and the witness to what has been previously marked as Exhibit 14. Do you recognize this document?
Yes, of course. This is the exact text exchange that Avery and I had this is from my phone. Yes.
Objection, Your Honor. This is not the exhibit in the final case correction. There was a case correction made regarding Exhibit 14, and this is not that final exhibit. The defense has the final case correction of Exhibit 14 if you wish to see it.
Ms. Leland, what's your response?
Your Honor, that it is true that this is a previous version of the exhibit. However, nothing that we are going to talk about has been factually changed, and we are comfortable accepting either exhibit, or at least nothing factual has changed that we will be bringing up in trial today. And we are comfortable using either the most recent exhibit or this one without any distinction between the two.
I think for
Response?
accuracy's sake, it's appropriate. The objection is well-founded, and it's appropriate to admit the ultimate exhibit that should be admitted. So the objection is going to be sustained. Procedurally, Ms. Tusek, is this something that you would be able to post immediately, or is this something that we can take that will give the jury the correct version?
Your Honor, the defense has the corrected version of Exhibit 14 if you wish to see that.
And Your Honor, additionally, if you wish to give our the prosecution about a minute or two, we could pull up the correct exhibit. But if the defense is willing to share theirs, that works as well.
Well, the other thing is, Ms. Leland, if your statement is the only questions you're going to ask remain the same from the non-revised version, why don't you continue with your examination, and then you can post the corrected version or the most updated version when it's available.
Yes, Your Honor. And just to make an offer of proof there, all that was changed between the exhibit that we are showing on that screen and the current one is there's a link to another app up in the corner that they wanted to disclude, as that was like a text creation app. And
Okay.
that is not something that we plan to talk about at all in court today.
Understood. On these grounds, the objection is sustained, and technically we'll get the correct exhibit in front of this witness.
Yes, Your Honor.
All right, Ms. Leland, go ahead.
For clarity's sake, are we allowed to enter with the previous version?
For now, and we'll swap them out as soon as the revised versions are ready.
Yes, Your Honor. We will, of course, do that.
Your Honor,
Ms.
excuse
Tusek.
me, but the defense does have the updated copy. If you wish the defense to screen share it for clarity's sake, since that is the updated copy. Though I believe this is the revised version.
Oh, great.
Now.
Thank you very much. All right, back to your questioning, Ms. Leland.
There we go. All right. So I think you just mentioned that you recognized that this was the text message you had between you and Miss Avery Becker. How do you recognize that this is that text message exchange?
Well, this is the exact exchange that went down, and this is from my phone. So these are the screenshots that I took.
And is this exhibit a fair and accurate representation of that exchange that you had with Miss Becker?
Yes, absolutely.
Your Honor, at this time, the prosecution moves to admit Exhibit 14 into evidence.
Ms. Tusek.
Yes, Your Honor, I object on the grounds of hearsay, as this is an out-of-court statement made by two declarants, as well as the fact that the exhibit as a whole is being offered for the truth of the matter asserted.
Ms. Leland, as to the statements by Mr. Cifuentes on the text message, but not the statements by Avery Becker, what is your response?
Yes, Your Honor, we are not offering these statements for the truth of the matter asserted, but rather for the effect that they had on the listener, as this is a back and forth conversation between the two, and ask that those statements be entered on the grounds for the sake of completeness and clarity. However, if you would like for us to exclude those exhibits, we are comfortable constructively redacting all of the statements by Alex Cifuentes.
What we're going to do is I'm going to overrule the objection. The exhibit shall be allowed. However, parties during closing statement may not be able to refer to the statements made in this text message by Mr. Cifuentes and argue it for the truth of the matter. So you're restricted by the limited grounds of admissibility of those statements during your closing arguments. Mr. Cifuentes, you may answer the question.
Mr. Cifuentes, could you read the fourth text sent by Ms. Becker?
Certainly. Avery wrote, "Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
And how about the fifth text?
I'm going to wait until he's at work, then break in and trash it."
And what was the last text sent by Ms. Becker?
The last text says, "That'll show him."
How did you react to these statements?
Given Avery's past actions, I took her at her word and thought she was being serious.
Co-counsel, we can stop screen sharing Exhibit 14 now. Mr. Cifuentes, did you talk to anyone about this text message exchange that you had with Ms. Becker?
Objection, Your Honor. The question calls for hearsay.
What's your response?
Your Honor, we're not offering a statement. This is merely a foundational question.
Overruled. Go ahead.
So did you talk to anyone about these messages?
No, I did not.
And why not?
I was quite conflicted at the time, given I was one of Avery's best friends, but also cared so much about Mr. Brackman. So I thought that being a high school teenager, if I said anything, I couldn't really do anything to stop it. And for that reason, I didn't do anything.
How do you feel about that now?
If I had any idea there would be a murder involved, I would have done everything in my power to stop that from happening. But I didn't. And now I live with the fact that I could have saved Mr. Brackman. And that will haunt me for the rest of my life.
Thank you, Mr. Fuentes. No further questions at this time, Your Honor.
Ms. Tusek, cross-examination.
Yes, Your Honor. Good morning, Mr. Fuentes. I'm going to start talking about a little bit about mock trial. Mock trial means a lot to you, correct?
Yes, I was a very dedicated team member.
You worked really hard on your assignments, didn't you?
Yes, I did.
You believe yourself to have a knack for it, correct?
Yeah, I was pretty talented and I really enjoyed it too.
Isn't it true that the way Miss Avery Becker participated in mock trial irked you?
Well, in some ways, because she tended to come to practice.
Thank you, Mr. Fuentes. I heard a yes. Now you consider yourself to be pretty equally skilled with Miss Becker, is that correct?
Yes, I'd say so. And we've definitely helped each other improve over the years.
But you believe that Miss Becker won her awards in mock trial, not because of any talent, but because of good looks, is that correct?
Yes, and yes.
And you were envious when Miss Becker won those awards, correct?
I'd say so, given how much time I put into it, but I was also happy to see my best friend succeed.
You were happy to see Miss Becker succeed, but you also saw it as a slap in the face, is that correct?
Yes.
Now let's move on and talk more about your relationship with Miss Becker. Now you claim you were basically best friends with Avery Becker, correct?
Yeah, we spent a lot of time together on the mock trial team.
But isn't it true that you think criminal charges should have been pressed against your best friend after the car incident?
Well, you must remember I'm a mock trial student, so I do know a lot about the law. And what Avery did probably should have been charges were pressed, but Mr. Bracken was a caring coach and chose not to.
You had a friendly competition with Avery Becker, correct?
Yes, that's just the nature of a team.
But isn't it true that you were excited for Miss Becker to get kicked off of the team because it meant that you would receive a larger role?
Well, I guess so, and I did try to get Avery back.
Thank you, Mr. Fuentes. I heard a yes.
Objection, Your Honor. Objection, Your Honor.
Hold on, Ms. Tusek. What is the objection, Ms. Leland?
Argumentative and counsel is testifying.
What's your response, Ms. Tusek, to the two objections of argumentative and counsel testifying?
Your Honor, this is a cross-examination and I have not testified for the witness.
I'm going to agree with Ms. Tusek and overrule the objection. Ms. Tusek, why don't you re-ask the question?
Yes, Your Honor. You were excited for Ms. Avery Becker to get kicked off of the team because it meant that you would receive a larger role. Is that correct?
Yes.
And isn't it true that you really didn't see your best friend, Avery Becker, that often outside of mock trial?
Well, no, but mock trial was kind of our life, so we spent a lot of time at practice.
Thank you, Mr. Fuentes. Now let's move on and talk about March 5th. You were at the Fry Shack on March 5th, correct?
Yes, that's correct.
You saw Miss Perkins and Miss Becker at the Fry Shack, is that right?
Yeah, we ran into them after mock trial practice.
You even talked to them, correct?
Yes.
And you played a game on Miss Becker's phone, correct?
Yeah, and it was really nice to see Avery again after she was kicked off practice.
So it's true then that you had Miss Becker's phone in your possession the day she lost it, correct?
Well, just for a moment, but most of the time we were just talking.
Thank you, Mr. Fuentes. This was the day before Mr. Brackman was killed, is that right?
Yes.
And let's move on to the interview that you had. Now you got a call to go down to the police station for an interview. Is that right?
Yes, that's correct.
And you were aware you were going down for a full interview, correct?
Yes,
And you knew that you needed to bring your phone to show the text messages you claimed to have received from Ms. Becker, correct?
yes.
But you didn't bring your phone, did you, Mr. Cifuentes?
Well, that was an entire mix-up as I left my phone at home because it was charging, but I
So
still
you
went down to
didn't
the
bring your
interview.
phone, correct?
Yes, accidentally.
And isn't it true that you sent screenshots the next day?
Yes, as the investigators asked me to.
So Detective Markowitz didn't see these text messages directly off of your phone for herself?
Well, the screenshots are directly off of my phone, so yes, he did see the text messages.
But she didn't see them directly off of your phone. She just received screenshots, correct?
Well, not my physical phone, but yes,
Thank you,
digitally
Mr.
they got
Cifuentes.
screenshots.
And coincidentally, you no longer have that phone, do you?
No, as I was saying, it had to charge a lot because of the battery, so I did get rid of it.
Now, isn't it true that when you received these text messages, the only person that you told was Detective Markowitz?
Yes, as the investigator called me.
So you didn't tell Mr. Brackman?
No, I did not.
You didn't notify the school?
I didn't.
You didn't call the police, did you, Mr. Cifuentes?
No, I didn't talk to the police until after the matter.
Right. So right when you received these text messages clearly containing a threat against Mr. Brackman, you didn't tell anyone, did you?
And it wasn't a threat directly against Mr. Bracken. It was a plan to break into his house, but no, I didn't tell anyone.
Thank you, Mr. Cifuentes. No further questions at this time, Your Honor.
Thank you very much. Any redirect examination?
Yes, Your Honor.
Go ahead.
Mr. Cifuentes, on cross-examination, you were asked about when you had Miss Becker's phone at the Fry Shack on March 5th. Did you steal Miss Avery Becker's phone?
Absolutely
Objection,
not.
Your Honor. Leading question.
What's your response?
It's an open-ended question. Did you do something or not? The witness is free to answer in either way.
The objection is overruled.
So, Mr. Cifuentes, did you steal Avery Becker's phone?
No, I did not.
What did you do on Miss Becker's phone when you had it?
Well, you must remember, Avery and I were friends, so I was just playing a game on her phone, but most of the time at that Fry Shack, I was talking to her and telling her how much I missed her and stuff like that.
I'd like to talk about your interview with the police regarding the evidence you brought to the case today. Why did you not bring your phone to that interview?
As I was saying, my phone tended to die a lot, so I was charging it before the interview. But in the rush of the moment of going to the police station, my dad and I left, and I forgot my phone behind. And we told the investigators this, and they were happy to get this.
Objection, Your Honor. Narrative.
Hold on one sec, Mr. Cifuentes. Do you have a response, Ms. Leland?
Yes, Your Honor. I asked why, and he's explaining his reasoning in a complete manner. That it's not a narrative question. He's not moving on to some other unrelated topic.
The objection is overruled. Why don't you finish your answer, Mr. Cifuentes?
Right, so, and going down to the police station, I forgot my phone. But I told the police officers this, and they were happy to get the screenshots following the interview.
And finally, Mr. Cifuentes, why did you not immediately tell anyone about this text message exchange you had?
I didn't tell anyone because obviously there is no trace that Mr. Brackman would be harmed. And given my situation being close to Mr. Brackman and Avery, I decided not to act.
If you didn't think that Mr. Brackman would be harmed by what this text message thread sent, what did you think?
I thought Avery was just kind of getting back to her antics, such as when she rode across the hood of his car. And I just thought Avery was simply playing a prank on Mr. Brackman and letting her anger out.
Did you believe what Avery Becker told you?
Yes, I did.
No further questions, Your Honor.
Okay, thank you very much, Mr. Cifuentes. You may step down. And will the prosecution call its next witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand. However, before we begin the direct examination, may I ask for a time check?
I'm not keeping track of time. I'm going to ask somebody. Oh, there's the timekeeper. Ms. Gammer?
Your Honor, I'm not the timekeeper for this side. However, I have 16 minutes and 23 seconds left.
Ms.
Yeah,
Boulder?
me too. Sorry about that.
Oh, that's fine.
Okay, thank you.
All right. Detective Markowitz, you are reminded you're already under oath. And is it Mr. Zias?
Zeitchis.
Zeitchis.
But yes.
Mr. Zeitchis, your witness.
Good morning, Detective Markowitz. What do you do for a living?
I'm a homicide detective.
How long have you been a homicide detective?
I've spent 13 years in the DPD and 7 years as a detective.
Do you have any specializations?
Yes, I specialize in the use of cell phone data.
Could you elaborate on what that means for the jury?
Yeah, I've got a cell phone technology and forensic data recovery certification, meaning I know how to interpret and, understand cell phone records and the data from that. I know how to use forensic software such as Celebrite, and I also know how to obtain and interpret cellular records along with cell tower records.
Do you use these skills frequently in your profession?
Constantly.
Have you downloaded the contents of phones before?
Hundreds.
And have you used cell tower records in any previous cases?
Yes, in over 50 cases.
Your Honor, pursuant to Rule 702, I move to admit Detective Jordan Markowitz as an expert in crime scene investigation with an emphasis on cell phone analysis.
What's the response from the defense?
Your Honor, I have no objection to this witness being entered in as an expert in those fields, but there is cross-examination prepared for this witness.
All right, then this witness shall be allowed to testify as an expert in the fields described under Rule 702. Your witness, Mr. Zeitchis.
Detective, could you tell us about the beginning of your investigation?
Yes, on March 6th, I was assigned to investigate the homicide of Mackenzie Brackman. When I arrived to the scene, he was face down in the entryway in a pool of blood, but I let the forensic team process that area while I investigated the surrounding area further.
Did you enter Mr. Brackman's house?
Yes, I entered into first the kitchen where I found an open knife drawer and a knife missing from the knife block. And then further into the dining room, there was—
Objection, Your Honor. Narrative, the witness is outside of the scope of the question.
What's your response?
Your Honor, the witness is just explaining what they saw in the house after entering.
Response, Your Honor.
Go ahead.
Your Honor, the question asked was, did you enter Mr. Brackman's house? The witness answered the question and then further continued to explain what she observed in the house. Therefore, it is outside of the scope of the question.
I think the objection you might be looking for is non-responsive.
I'm sorry, Your Honor, you cut out for me. Could you repeat that?
I overruled the objection and allowed the witness to answer.
Yes, Your Honor.
So as I was saying, then I found a broken plate on the floor in the dining room and a knocked over chair.
I'm directing your attention to what has previously been marked as Exhibit 9. Do you recognize this photo?
Yes.
And how do you recognize this photo?
It is a photo of the broken plate found at the crime scene.
Is it a fair and accurate representation of the broken plate that you found?
Yes.
Your Honor, I move to admit Exhibit 9 into evidence.
Any objection from the defense?
No objections, Your Honor.
Exhibit 9 shall be admitted.
What does this broken plate tell you?
It indicates that there was a struggle between the intruder and the victim.
After seeing this broken plate, what did you do next?
I then wanted to download the phone contents from Mr. Brackman's phone, along with get the Ring security footage, since I did see he had a Ring doorbell.
Could you briefly explain what Ring is for the jury?
Yeah, Ring is a home security system that consists of motion activated cameras connected to a doorbell.
Did you end up obtaining any of this Ring footage?
Yes, all of it.
Would you recognize a video if I showed you?
Yes.
Your Honor, I'm directing the witness to what has previously been marked as Exhibit 10. Do you recognize this video?
Yes, it is a video of the intruder taken in the front Ring video camera.
Is this a fair and accurate representation of the video that you obtained from Mr. Brackman's Ring account?
Yes, it is.
Your Honor, I move to admit Exhibit 10 into evidence.
Any objection from the defense?
No objections, Your Honor.
Exhibit 10 shall be admitted.
As we play this video for you again, what does this video show?
Yeah, so we can see the intruder attempting to first enter in through the front of the house, seeing the door is locked, and then ultimately going around back. The intruder in the video is the same size and build as the defendant in today's case.
Now let's move on. Did you interview any witnesses in today's case?
Yes, after seeing on Mr. Brackman's phone the amount of time he put into mock trial as a coach, I wanted to interview one of their members, Alex Cifuentes.
What did you learn from this interview with Mr. Cifuentes?
He referred to text messages Avery had.
Objection, Your Honor. Hearsay.
And what's your response?
Your Honor, no out-of-court statement has been offered for the truth of the matter yet, so therefore there's no hearsay.
Response, Your Honor.
Go ahead.
Your Honor, the witness just testified to Mr. Cifuentes referring to something, and to refer to something is an out-of-court statement, and therefore it is hearsay.
And I'm going to sustain the objection to the specific response from this witness. You may reframe the question or ask another question.
I'm directing your attention to what has previously been entered as Exhibit 14. Do you recognize this screenshot?
Yes.
What are they?
These are the text messages that Alex Cifuentes provided our investigation.
Can you read the fourth and fifth text messages for the jury?
Yes, so the first one is, well, if he's still upset about his car.
Objection, Your Honor. Cumulative. Another witness has already testified to this exact message.
And what's the response?
Your Honor, this question is being asked to lay foundation for more future questions.
The objection is overruled.
Could you read the fourth and fifth text messages for the jury?
Yeah, so as I was saying, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. And then the following line is, I'm going to wait until he's at work, then break in and trash it.
How did these text messages influence your investigation?
These text messages prompted me to investigate Avery Becker.
How did you investigate the defendant?
I was able to get their cell phone number, and then I contacted the service provider to get their call detail records.
Could you explain what call detail records are?
Yeah, I'll just refer to them as a CDR. A CDR is a record of a phone or text interaction connected through a cell tower. It shows us, date, time, if it was an incoming or outgoing, and most importantly, it shows us the location of a cell phone.
I'm directing your attention to what has previously been marked as Exhibit 16. Do you recognize this document?
Yes.
What is it?
It is a diagram that I made from Avery Becker's call detail records.
And what is the dotted line on this document?
The dotted line shows us the likely route Avery Becker took during and,
Objection, Your Honor. Assuming facts not in evidence, this exhibit has not been admitted yet.
I'm going to overrule that part of the objection just because he's trying to lay a foundation, and then I'm going to let you object.
Yes, Your Honor.
Is this a true and accurate representation of your diagram?
Yes.
Your Honor, I move to admit Exhibit 16 into evidence.
Do you have an objection to the admission of Exhibit 16?
Yes, Your Honor. This blue line that was drawn by Detective Markowitz in the process of creating this diagram is an out-of-court statement. So therefore, it is hearsay as it is offered for the truth of the matter asserted to show Ms. Becker's path to get to Mr. Brackman's house.
And for that reason, you're objecting to its admission altogether?
Yes, Your Honor.
Do you have a response, Mr. Zeiches?
Your Honor, I don't see how a dotted line is an out-of-court statement being offered for the truth of the matter asserted.
What I'm going to do is I'm going to overrule the objection, but I'm going to tell you, Ms. Mastrangelo, you may cross-examine on that subject during your portion of the examination.
Yes, Your Honor.
All right, so the evident Exhibit 16 is admitted, and you may ask your next question.
Detective Markowitz, what do the call detail records of today's case show you?
It shows us the location of Avery Becker's cell phone around the time of the murder. As you can see in the top right of the diagram, around 12:45 or 47, excuse me, their phone connected to the cell tower closest to the Becker residence. And then kind of in a midpoint around 12:55 connected to a middle cell tower. And then finally at Mr. Brackman's residence, their phone connected 3 times to the same cell tower between 1:07 and 1:15.
Is this consistent with the timeline of the murder?
Yes, it is.
Detective Markowitz, in your expert opinion, how did Mr. Brackman die?
He likely died in the scenario of he was alerted that there was a intruder from his Ring security system. He then went into his kitchen to grab a knife and arm himself against incoming intruder. There was some kind of
Objection, Your Honor, lack of foundation. The knife that the prosecution claims Mr. Brackman has picked up has not been talked about before this expert opinion.
What's your response?
It has been talked about at the beginning of my direct examination when I asked the detective what she saw inside Mr. Brackman's house. She mentioned how she saw Mr. Brackman lying next to a pool of blood with a knife nearby. And she also testified to seeing a knife drawer open and a knife missing from the knife block.
The objection is overruled. Detective, you can finish your answer.
So, like I was saying, he grabbed a knife to arm himself against the incoming intruder. There was some kind of altercation, and ultimately he was stabbed.
Who was this intruder?
The defendant in today's case, Avery Becker.
How do you know that it was Avery Becker?
Based on the previous relationship between the two, the text messages detailing Avery's plan, also the person in the video was the same size and build as Avery Becker. It is clear that Avery went to Mr. Brackman's residence planning to commit an act of vandalism, but it went wrong.
Thank you. No further questions at this time.
Do you wish to cross-examine the detective?
Yes, Your Honor.
Your witness.
Good morning, Detective Markowitz. I'm going to start by asking you some questions about your investigation. Now, isn't it true that Mr. Brackman was a criminal defense attorney?
Yes, he was.
And isn't it true that this crime could have been committed by a disgruntled ex-client?
That was a possibility, but there was ultimately nothing pointing us towards that.
But it was something to consider, yes?
Yes, and as an investigator, I considered.
Thank you, I heard a yes. Now, but you went to the mock trial team for leads first, correct?
After going through his cell phone, seeing how much time he put into it, I had to follow that.
But it seemed highly unlikely that mock trial had anything to do with his death, isn't that right?
That's why I do my job. You have to explore the possibilities, the likelies, the unlikelies. So I was just doing my job.
Now let's talk about exploring possibilities. Now, you didn't look into any other suspects, did you?
There was nothing that was leading me towards other suspects.
Now let's talk about the way in which you gathered your evidence. Now, you spoke to Mr. Cifuentes, correct?
Yes, I interviewed him.
And you received screenshots of text messages that were between Ms. Becker and Mr. Cifuentes from him,
Yes.
correct?
Yes, you are correct.
And these were just screenshots, right?
In our line of work, we use screenshots, records, copies all the time. So,
Detective Markowitz, you're not answering my questions. Were these messages just screenshots?
screenshots, copies, however you want to phrase it.
Now, you only received these screenshots because Mr. Cifuentes forgot to bring his phone to the meeting. Isn't that right?
Yes, he didn't have his phone, but it wasn't a huge issue.
And now Mr. Cifuentes then sent you the screenshot of the messages the next day. Isn't that right?
That's when we received them.
And he was supposed to send you these screenshots as soon as possible. Isn't that right?
I was doing my investigation. There was plenty of things I had to do, so getting them the next day was perfect for our investigation.
So in a murder trial, receiving these screenshots the next day was sufficient enough for you. Isn't that correct?
We were working through all of the evidence. The only evidence is not just these text messages. We have a lot of evidence that we have to process.
Detective Markowitz, you're not answering my question. It was sufficient enough for you to receive these screenshots the next day in a murder trial. Isn't that right?
Yes, we're taking our time, doing our due diligence, figuring out what happened.
Thank you, Detective Markowitz. I heard a yes. And now you never saw these text messages on the authentic phone, now did you?
That isn't a huge issue. We get copies of things all the time.
Now let's talk about the cell detail records you collected. Now you collected cell detail records from Ms. Becker's phone, correct?
Yeah, they are call detail records, and I got them from Avery Becker.
And now you saw that Ms. Becker received many short calls from Ms. Perkins, correct?
Yes, they were not picked up. So
Thank you, Detective Markowitz. I heard a yes. And now it's likely that these calls were never answered, correct?
Yeah, considering what was happening at the time, what was going on, it's not shocking that Avery didn't.
Thank you, Detective Markowitz. I heard my answer. And now, Detective Markowitz, Ms. Becker also received many texts from Ms. Perkins that were also never answered, correct?
Yeah, as shown on the diagram.
And now it's to your understanding that Ms. Becker claims to have lost her phone the day previous to these calls and texts, correct?
That's the interesting thing about investigations is there's only so many coincidences that can be credible. So
Detective Markowitz, that isn't my question. My question is that, Detective Markowitz, that wasn't my question. My question is that it is to your understanding that Ms. Becker claims to have lost her phone the day previous. Yes?
She claims to have lost her phone, but that is not consistent.
Thank you, Detective Markowitz. I heard a yes. And now, Detective Markowitz, let's talk about the cell tower diagrams you collected. Now, you collected cell tower diagrams from Ms. Becker, correct?
Yes.
And now, it's possible that Ms. Becker's phone couldn't have connected to the nearest tower, but instead a farther away tower, correct?
Yeah, I'm actually glad you brought that up. There are plenty of kind of scenarios and options you have to rule out. So, are we in a city? Is it raining out? Are there many people in this area? Are there tall buildings? And actually, none of that was the case. So the likelihood of it connecting to a further tower was less likely because it's a residential area during a work weekday, meaning there's not that many people.
Thank you, Detective Markowitz. I will continue to ask you some questions about this, and then you can answer my questions. Now, Detective Markowitz, it's possible that Ms. Becker's phone didn't connect to the nearest tower because of the reasons you just stated. Yes?
Yes, but like I just said.
Thank you, Detective Markowitz. I heard a yes.
It's
now,
Detective, considering the scenarios of they weren't in the city, it wasn't raining, there weren't a ton of people.
Objection, so Your Honor. Would you please instruct the witness to just answer the question asked and just the question asked?
So, Detective, in this case, you've been asked a question, you've answered the question, and you just wait for the next question. The remaining portion of what you just described will be stricken for the record.
Thank you, Your Honor. Now, Detective Markowitz, let's talk about the cell tower records you didn't collect. Now, it's to your understanding that Ms. Perkins was the one calling and texting Avery Becker, yes?
Yes, as shown in Avery's call detail records.
And now, but you didn't collect Ms. Perkins' cell tower records, did you?
There was no need to.
Right, let's look at that. Now, Ms. Karras, would you please screen share Exhibit 16 as it has already been admitted? Now, Detective Markowitz, would you please direct your attention to the upper left quadrant of this exhibit? And now there's a marked location there, isn't that right? Blair Rollins' house?
Yes, we have Blair Rollins' house along with Avery Becker's house.
And now, Detective, you created this diagram, yes?
Yes, I did.
And you marked this location, Blair Rollins' house, yes?
Yes, while I was going through my investigation.
And now, Detective Markowitz, you marked Blair Rollins' location, but you didn't collect cell tower records for Blair Rollins that day?
Like I said, I made this during the creation of my investigation. It wasn't at the end of the investigation.
Thank you, Detective Markowitz. I heard a no. And now, Detective Markowitz, you only collected this cell tower diagram for a very limited period of time. Isn't that right?
He wasn't killed over a course of 24 hours. There was a certain amount of time that, we know there was somebody at the scene.
Thank you, Detective Markowitz. Now, according to your methods, you are sure that you can pinpoint Miss Becker's location near Mr. Brackman's house using these diagrams, correct?
It is a general area, but that's why we use them so we can locate where a phone is.
Now let's talk about that. So say if you had collected Blair Rollins' cell tower records, you could also pinpoint Blair Rollins in this area, according to your methods, of course, correct?
There was nothing leading us to...
Detective Markowitz, that wasn't the question. The question is if you could or could not pinpoint Blair Rollins' location with the cell tower records. Yes?
Yeah, you can do it with anybody, but...
Thank you, Detective Markowitz. I heard a yes. And now, Blair Rollins, if you had collected Miss Perkins' cell tower records, you could also pinpoint Miss Perkins' location according to your methods, correct?
Again, you can find anybody's location, but there was nothing prompting us to have to find their location.
Right. And you didn't, did you?
Because there was no evidence pointing towards that.
Thank you, Your Honor. No further questions at this time.
Mr. Zeitges, any redirect examination?
Yes, Your Honor.
Go ahead.
Detective Markowitz, on cross, they challenged the authenticity of the screenshots that Alex Cifuentes sent you. In your expert opinion, are those screenshots authentic?
Yes, they are.
Objection,
Also,
Your Honor. This is outside the scope of the expertise of the witness.
What's your response, Mr. Zeitges?
This expert has an emphasis on cell phone analysis, and therefore it is in the witness's field of expertise.
Response, Your Honor?
Go ahead.
Your Honor, the witness is not entered as an expert in authenticating text messages, so therefore it is outside the scope of the expertise.
The objection is overruled and the detective may testify.
Yes, Your Honor.
How do you know that these screenshots were in fact authentic?
There was nothing pointing us to indicate that they weren't authentic. They are true text messages.
Well, additionally on cross, they alleged that Avery Becker's cell phone could connect to any of these towers. Is this true?
Yes, but you have to go through all of the factors, and it wasn't raining, it wasn't a busy area, so it's actually accurate where the cell phone was.
And finally, why didn't you investigate Blair Rollins?
There was no motive, no evidence pointing towards Blair Rollins.
Was there enough evidence to know certainly that it was Avery Becker?
Yes, she has a history of vandalizing Mr. Brackman's property, a history of a contentious relationship between the two, and, plans a detail in text messages of a plan to vandalize his house.
Thank you. No further questions at this time.
Thank you, Detective Markowitz. You may step down. Prosecution, do you have any other witnesses?
Yes, Your Honor. The prosecution calls Ms. Kyle Kuzak to the stand.
Ms. Kuzak, you are reminded that you are under oath, and Ms. Fawn, your witness.
Good morning, Ms. Kuzak. Please introduce yourself.
Hi, I'm Kyle Kuzak.
And what is your occupation?
Well, I'm a CSR, so a certified crime scene reconstruction investigator under the Colorado Bureau.
How many years of experience do you have?
Oh, tons. About 19 now.
And what does your role as a CSR entail?
Well, mainly I look at more complex crime scenes, so that would be your homicides, your armed robberies, your burglaries, things of that nature.
And what conclusions do you make in your work as a CSR?
So it's my job to look at all of the available evidence and essentially reconstruct it.
And how do you actually analyze these criminal events?
Well, I have my favorite methodologies from Tom Bevel and Ross Gardner, 5 steps. And that basically means that I take whatever I can get my hands on and transform it into event segments.
Your Honor, pursuant to Rule 702, the prosecution moves to enter Ms. Kuzak as an expert in crime scene reconstruction and forensic analysis.
What's the response from the defense?
Your Honor, I do not object at this time. However, I do have a cross-examination prepared for this witness.
All right, so here's what we're going to do. This witness may testify as an expert under Rule of Evidence 702 under the proposed scope and or of expertise, and you may cross-examine when the prosecution is done. Back to you.
Ms. Kuzak, how did you come to be involved in the case today?
Well, I work with the Denver Police Department, so when a case goes to them, it also goes to me.
And what were your responsibilities in this specific case?
It's my job to look over everything available. So first off, I visit the crime scene in question, and then I review all of the available evidence.
And do you believe that the conclusions you made were the fair result of all the evidence you reviewed?
Absolutely. I hold myself to the highest personal standard. But on top of that, I also send all of my work and conclusions through a gauntlet, if you will, of my colleagues to make sure that everything is thorough and comprehensive.
I would like to talk about your conclusions. What is your timeline of the initial events that happened?
Well, first off, if you take a look at the security footage that I reviewed, you can see an intruder walking up to the front of Mr. Brackman's home and then slowly making their way around to the back.
And do you know why this intruder was trying to enter the home?
Yes, it's my belief that the intruder was attempting a burglary. It was the middle of the day, and all evidence points to them just intending to enter the home and burglarize it.
Was anyone home during this attempted burglary?
Unfortunately, yes, the decedent, Mr. Brackman, was home.
And did he know that someone was breaking and entering into his home?
Objection, Your Honor, speculation.
And what's the response to the objection of speculation?
Your Honor, Ms. Kuzak has been entered as an expert in crime scene reconstruction, and the basis of crime scene reconstruction is reconstructing a timeline of the events that happened during this crime. And whether or not Mr. Brackman was alerted to this intruder is a key part of the timeline and the conclusion she made.
Response,
So
Your Honor?
Oh, go ahead with your response.
Your Honor, this is speculation as we cannot know what Mr. Brackman saw, heard, or did. And so it is speculation.
So here's how I'm going to do what I'm going to do. I'm going to overrule the objection, but you're going to have to re-ask the question as if you know to the prosecution. All right. If you could re-ask the question with that modification.
What was Mr. Brackman doing while this intruder was breaking into his home?
Well, he was sitting at his kitchen table.
And what happened then?
It's my belief that he was alerted to the presence of an intruder, either from the noise of them breaking in or the alert system on his Ring videos. And then from there, he got up, got a weapon as a means of defending himself. So in this case, a chef's knife. And then he went and met the perpetrator at the back door.
And what happened next?
From there, the two engaged in a struggle over the knife.
What evidence did you have of a struggle?
Well, there were the scuff marks by the back door, which indicates to me a shifting of weight, a struggle between two bodies. But then on top of that, there was a broken plate in the kitchen on the floor, which again indicates to me thrown about weight, struggling bodies, all signs of a struggle.
Your Honor, let the record reflect that I am showing Ms. Kuzak what has previously been marked as Exhibit 4. Are you familiar with this photo, Ms. Kuzak?
I am. That's the body of the decedent, Mr. Brackman.
Is this a fair and accurate representation of the body?
Yes.
Your Honor, I move to admit Exhibit 4 into evidence.
Ms. Karas,
No objections, Your Honor.
Exhibit 4 shall be admitted.
Permission to publish to the jury.
You may.
What does this photo tell you, Ms. Kuzak?
Well, if you look closer, which I know is difficult as gory as the image is, you can see that the stab wound on the decedent's back is horizontal, which immediately indicates the position in which Mr. Brackman was stabbed. The perpetrator got him in a kind of bear hug, and from there wrapped their arm around and stabbed him horizontally.
And so what happened after Mr. Brackman was stabbed?
The perpetrator fled through the front door.
And then what did Mr. Brackman do?
He attempted to go after them, but ultimately failed. And then from there, at that front door, he pulled the knife from his body.
Your Honor, let the record reflect that I'm showing the witness what has been entered as Exhibit 14. Ms. Kuzak, can you please read for us the fifth text on the left side?
Objection, Your Honor. Cumulative. This text message has already been entered and read. Also, this witness is not an expert in cell phone technology and cannot testify to what is in these text messages.
What's the response from the prosecution?
Your Honor, first of all, with regard to cumulative, this is not cumulative because Ms. Kuzak will be reading this text message in regards to her conclusion of the events that happened. And in terms of the objection due to personal knowledge of cell phone analysis, Ms. Kuzak is not testifying on whether these are legitimate text messages. She is testifying as to make an offer of proof. She'll be testifying as to the plan laid out in these text messages and how that relates to her expert conclusions.
And on the two grounds of the objections, both are overruled. You may answer the question.
Ms. Kuzak, can you read for us that text, please?
Definitely. It says, I'm going to wait until he's at work, then break in and trash it.
And is this plan laid out consistent with your timeline of what happened?
Absolutely. Someone indeed waited until they thought Mr. Brackman was at work, and then they broke into his home and did what they intended to do, which was burglarize it or attempt to.
And so, Ms. Kuzak, what were your final conclusions in this case?
Well, Mr. Brackman was stabbed as a result of an altercation, and ultimately the altercation was a result of a burglary gone wrong.
Thank you, Ms. Kuzak. Your Honor, no further questions at this time.
Cross-examination for the defense.
Yes, Your Honor. Good morning, Ms. Kuzak. Isn't it true that you arrived at the crime scene after it had been processed?
I did, yes.
And this meant that you had to rely on previously gathered evidence, such as police reports and photographs, correct?
Well, besides visiting that crime scene, I also did rely on information collected by my colleagues.
Now, please draw your attention to Exhibits 1, 2, and 4, which you have in front of you. Can you identify what is in Exhibit 1 for the jury?
Well, it's the body of the decedent, Mr. Brackman, who was stabbed.
And can you please identify Exhibit 2 as Exhibit 4 has already been entered?
Again, that's the picture of the decedent with a pool of blood around him.
And is Exhibit 1 a fair and accurate representation of the body?
Yes, it is.
And is Exhibit 2 a fair and accurate representation of the body?
It is.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified Exhibits 1 and 2. Your Honor, I now move to enter Exhibit 1 into evidence.
Any objection for the prosecution?
Yes, Your Honor, I object to Exhibit 1 being entered into evidence based on Rule 403, as this exhibit is more prejudicial than it is probative, and this bloody photo goes to inflame the passions of the jury and doesn't offer any significant probative value.
I'm going to overrule the objection and allow Exhibits 1 and 2 into evidence.
Yes, Your Honor. Now, please look at Exhibit 1. And then look at Exhibit 4. The victim's right hand is not in the same position in these two photographs. Isn't that correct?
I guess not the exact same position.
Thank you, I heard a yes. Now please look at Exhibit 2. Isn't it true that Mr. Brackman has what appears to be a wedding band on his left ring finger?
He does, yes.
And these matters are not mentioned anywhere in your report. Isn't that correct?
Well, I'm not sure what importance a wedding ring is to this case, but also, if you'll recall, as you said, the scene was processed
Ms.
before I
Kuzik,
got
you're
there.
not answering my question. These matters are not mentioned anywhere in your report, are they?
No, but again, I'm
Thank
not.
you. I heard
Objection, Your Honor. This calls for hearsay.
What's the response to a hearsay objection?
Your Honor, the witness can testify to the report that they created themselves without actually being entered into evidence.
I'm going to overrule the objection. The witness may answer the question about what was in her report.
Thank you, Ms. Mastrangelo. You can stop sharing the screen now. I am next going to ask you about your theories in regard to the knife. You determined based off of the autopsy report that the knife was lodged in the victim's scapula, correct?
It was, yes.
And this would make it very hard to pull out the knife, correct?
Indeed, but if you'll recall the pictures.
Thank you, I heard a yes. And even considering this, isn't it true that you claimed that the already weak victim must have pulled out the blade himself?
I'm sure he did. And again, if you'll recall.
Yes. You also took
Objection,
a
Your
photo.
Honor. Badgering the witness.
Hold on. Ms. Fan, you had something to say?
Yes, I objected to opposing counsel badgering the witness as she is not allowing Ms. Kuzik to finish her response to the question asked.
And Ms. Karas, what's your response to the objection of badgering?
Answered the question that was asked of them, and they are yes or no questions, which means that any further explanation is not within the scope of the question anymore.
Okay. Under these grounds, I am badgering. I'm not aware of a badgering rule of evidence. Is there something you could point to, Ms. Fan?
No, Your Honor, I'm simply objecting to opposing counsel cutting the witness off before allowing her to finish her complete testimony.
Okay. And the objection in this case is overruled. Continue your cross-examination.
Yes, Your Honor. You also took a photo of the knife, correct?
I did, yes.
And would you recognize this photo if I showed it to you?
I would.
Ms. Mastrangelo, can you please show Exhibit 6 to the jury, or to Ms. Kuzik? Can you identify what is in Exhibit 6?
Yes, so that's the murder weapon itself.
And is this a fair and accurate representation of this murder weapon?
Yes, it is.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified Exhibit 6. Your Honor, I now move to enter Exhibit 6 into evidence.
Is there an objection?
No objection, Your Honor.
It shall be admitted.
And you notice the blood on the handle seen in this knife, correct?
I do, yes.
Now please draw your attention back to Exhibits 1 and 4. Do you see any blood on the victim's hands?
In the pictures, the bottoms of the decedent's hands aren't shown, so I really can't see if there was blood on his hands or not.
Next, I'm going to ask you about the missing files. Isn't it true that part of your reconstruction relied on photographs of the blood spatter?
A small part of my investigation, yes.
And these photos no longer exist, correct?
Unfortunately, they were corrupted, but I got a very good look.
Thank you, I heard my answer. So neither the jury nor the defense has access to those, correct?
No, they don't.
Now, finally, I'm going to ask you about the conclusions that you made. You assumed that there was no way for the victim to have been surprised by the intruder, correct?
Well, I didn't assume that there was no way, but it seems to me most likely that the decedent was alerted.
And isn't it true that you assumed that Mr. Brackman received alerts from the Ring app?
I didn't assume. Again, it seemed more likely. And as well, they must have heard an intruder.
And you have no physical evidence of them either hearing the intruder or having these notifications, correct?
No, but again...
Thank you, I heard no. And you further assume that if Mr. Brackman received the alerts, he chose to engage the potential intruder, correct?
Well, he chose to grab a means of defending himself. He met the perpetrator at the back door. The choice to engage was that of the intruder.
Finally, you claim that you prefer having more physical evidence. Isn't that true?
That's always true for someone in my profession. We prefer to be as thorough as possible, but in this case...
Thank you, I heard the answer. And this means that you did not have all of the evidence in order to recreate all segments of the event, correct?
Not all segments, but again, that's not unusual.
No further questions yet, Your Honor.
Any redirect examination?
Yes, Your Honor, briefly. Ms. Kuzik, what did your expert report include?
Well, my report included all sorts of things, the timeline, as well as several suspects, as well as the means of stabbing, everything I needed.
And did the photos of the blood splatter support your conclusions?
They did, but not to a large degree. So in the end, it didn't really matter that they became corrupted after I'd seen them.
And finally, what evidence led you to believe that Mr. Brackman was alerted to an intruder?
He had a state-of-the-art security system that's meant to alert people in ownership of that system. And furthermore, he would have heard somebody breaking into his home if he was sitting at his kitchen table, which he was.
Objection, Your Honor. Speculation.
What's a response to the speculation objection?
Your Honor, this doesn't call for speculation, as Ms. Kuzak is an expert in reconstructing the timeline of the crime, and I believe the only thing she has testified to are these expert conclusions as to the timeline of what happened on the day of the crime.
Response, Your Honor.
On those grounds only, but you can't, detective, you can't speak to what was in the head of the victim.
And Ms. Kuzak, what did Mr. Brackman do that told you he was alerted to the crime?
He went and got a means of defense to meet the intruder.
No further questions, Your Honor.
Stop.
Thank you very much. And it's perfect timing because we're out of time. As far as for the prosecution, do you have any other witnesses?
No, Your Honor.
All right, what we're going to do is we're going to take a brief 2-minute recess to use the restroom, and we'll see everyone back here in 2 minutes. Are the parties ready for the defense to present their side of the case?
Yes, Your Honor. The defense is ready to proceed.
Thank you, Ms. Karras. Is it Karras or Karas?
Your Honor, it's Karras. You're correct.
Karras.
Your Honor, would you like confirmation from the prosecution that they are ready?
Yes.
Thank you.
All right. Do you have your witness ready, Ms. Karras?
Yes, Your Honor. The defense calls its first witness, Ms. Taylor Perkins, to the stand.
Ms. Perkins, I want to remind you, you are under oath. Ms. Karras, your witness.
Good morning, Ms. Perkins. Will you please introduce yourself to the jury?
Good morning. My name is Taylor Perkins, and I'm a freshman at CU Boulder.
Ms. Perkins, why are you here today?
I'm here today because Avery did not do this. She was with me the entire day of March 6th.
Can you be more specific about the time that you were together?
Sure, we were together the morning, the afternoon, and into the evening.
And what's the significance of this time period?
Well, to my knowledge, this is the time that Coach Brackman unfortunately died.
Now, let's talk about your relationship with Ms. Becker and mock trial. Why did you join mock trial?
Well, I joined mock trial mostly to be with Avery. She's my best friend.
Did you enjoy mock trial?
Oh, I do. Yeah, I mean, it's super fun, and I think that I'm actually pretty good at it.
Was Ms. Becker good at it?
Avery was amazing. I mean, it was frankly inspiring to watch her.
Now, let's move on and talk about some of the relationships in mock trial. What was your relationship like with Mr. Brackman?
Coach Brackman and I, we had a basic student-teacher relationship. The only time we would talk was during practice.
And from your observations in these practices together, what was the relationship like between Mr. Brackman and Ms. Becker?
Well, from my observations, Avery and Coach had an interesting relationship. I mean, they both really cared about mock trial, just in different ways.
And how do you know this?
I know this because I was Coach's student, and from that experience, I learned that he really liked organization and structure, and he didn't like it when students went off their script.
Did Ms. Becker stay on script?
Well, Avery was a natural when it came to mock trial, so she didn't really need one.
Now, let's talk about some conflicts that you observed. What happened when Ms. Becker went off script?
Well, this one time, Avery came into practice, and she was really, really unprepared, I think, and she just went off script, and well, Coach actually demoted her down to the B team. And you know, she was later kicked off of the team.
And what did you decide to do after Ms. Becker was demoted to the B team?
After she was demoted, I decided to leave the team.
Why did you make that decision?
Well, I made that decision because I knew that if I left, Coach Brackman would bring Avery back up to the A team, and then the team would have a better chance of making it to state, which was what we all really wanted.
And you mentioned that Ms. Becker was then kicked off of the team. What happened after this?
After this, Avery had tried to apologize to Coach for, you know, the incident that got her kicked off of it. But, you know, Coach stuck with his decision.
And what happened after Ms. Becker apologized to Mr. Brackman?
Well, like I said, Coach stuck with his decision. So I talked to Avery about different ways, you know, she could possibly try to get back on the team. And we decided that she should try and talk to Coach again.
And what happened next?
Well, Coach, he didn't want to talk to her. So I talked to her again, and we decided that she should try to reach out to other team members to see if maybe they had any ideas.
And what was the result of this?
Well, no one did have any ideas, so, you know, nothing happened.
Now, I'd like to move on to the night of March 5th. What did you do that evening?
That evening, Avery had come over to my house, and we hung out a little bit, and then we headed to the Fry Shack.
And what happened while you're at the Fry Shack?
Some mock trial team members actually showed up.
And once the mock trial members arrived, what happened?
After they arrived, at one point, Avery, she put her phone down on the table and went to the bathroom.
Then what happened?
Well, Avery came back from the bathroom, and we decided to go to the mall because there were some pretty awesome sales going on that day.
Now, let's talk about the day of March 6th. What happened that morning?
Well, that morning, I had texted Avery to see if she was going to pick me up for school, but she never answered my text.
Then what happened?
Well, Avery actually did come over to my house to pick me up, and, you know, I talked to her about why she didn't answer my text, and, well, that's when we realized that her phone was actually missing.
What did you decide to do after that?
After that, we decided to, go look for her phone because it's really important to her.
Where did you go first?
Well, the first place we went was to the mall because we had to retrace our steps from the night before.
What did you do at the mall?
Well, at the mall, we had to go through every single store we went through the night before, which was, pretty much all of them. So we burned through the whole day looking.
And what happened after you spent the whole day at the mall?
Well, like I said, we burned a lot of time there. So we got hungry. And I also remembered Avery putting her phone down on the table at the Fresh Shack the night before. So we headed there.
And what happened next?
After that, some team members actually came to the Fresh Shack, which, I thought was pretty weird.
What happened after they arrived?
After they arrived, I learned that Coach Brackman didn't show up to practice, and that's actually why they were there.
And why did Mr. Brackman not arrive at practice?
Well, I later found out that he didn't show up because he was actually dead.
And once you found out that Mr. Brackman was dead, what happened?
Avery's lawyers actually called me about being a witness, and well, I was shocked.
Why were you shocked?
Well, Avery shouldn't even need lawyers. I mean, she didn't do it.
And how can you be so sure?
Avery was with me the entire day that Coach Brackman died. And, we went to the mall and the Fry Shack, nowhere even near Coach's house.
Thank you. No further questions at this time, Your Honor.
Any cross-examination?
Yes, Your Honor.
Go ahead.
Ms. Perkins, let's talk about how Ms. Becker fit in with Mr. Brackman's vision for the mock trial team. Mr. Brackman wanted the team to be well prepared, correct?
I definitely think he wanted us all to succeed, so yes.
He also wanted the team to stick to their scripts?
Yeah, like I said, he liked organization and structure, so he really did like when we stuck to our scripts.
He really liked it, but Avery didn't do these things, did she?
Well, like I said, Avery was a natural, so she didn't need a script.
Avery was often unprepared?
I definitely think she came unprepared to practice a few times, yes.
And often late for practice?
She was. I mean, we all have other things outside of mock trials, so, who isn't late sometimes?
But Avery was good at improvising and making things up on the fly, wasn't she?
Well, I think that's a really important skill to have, especially when, you're pretending to be a lawyer.
Thank you. And in your words, she could even be rash at times.
Yes, but definitely not irrational enough to commit murder.
But
like you guys are insinuating.
But she was irrational enough to play pranks on Mr. Brackman.
Only things that wouldn't harm anyone.
Things that wouldn't harm anyone? Such as vandalizing Mr. Brackman's car?
That didn't harm anyone. It harmed the car.
And Miss Becker did write Worst Attorney Award on the hood of this car, didn't she?
Well, I wasn't there, so I wouldn't actually know, but I did, find out that that's what, was written there, but I can't know for sure.
So a message like that wouldn't be hurtful?
Well, I suppose it could be, but, it's not physical harm.
So were these pranks hurtful or not hurtful?
I don't know. I wasn't the one who was on the receiving end.
Okay. You also thought that Avery could have an inflated ego at times, right?
Well, everyone can, but yes.
And both of you believed that Mr. Brackman wasn't a good coach.
Objection, Your Honor. Speculation. Ms. Perkins cannot know what Ms. Becker believes, as she is not Ms. Becker.
What's your response?
Because Ms. Becker and Ms. Perkins are such good friends and teammates, this is rationally based upon the witness's perception.
I'm going to overrule the objection. The witness may answer if she knows.
Both you and Avery thought that Mr. Brackman wasn't a good coach, correct?
I thought he was a mediocre coach. I definitely think that he could have made some better choices for the team.
Yeah, you both believed he made bad choices for the team.
Like I said, he could definitely make better ones.
And one of these bad choices was demoting Avery from the A team to the B team before regionals, correct?
From my perspective, yes. Avery made the team a whole lot better.
So you stepped down because you were friends with Ms. Becker, correct?
No, I actually stepped down because I wanted the whole team to succeed.
But also because you were friends with Miss Becker, correct?
Well, I mean, I guess that was part of my decision.
And this forced Mr. Brackman to put her back onto the A team, didn't it?
Well, yes.
And Avery got Best Attorney Award at this regional tournament.
Yeah, she's very, very good.
But Mr. Brackman wasn't very pleased with this, was he?
Well, I mean, I was off of the team at that point, so I don't know how he felt, but that's what I heard, yes.
And this made Miss Becker quite heated, correct?
Well, from my perspective, again, I wasn't there, so.
And this prompted Miss Becker to go vandalize Mr. Brackman's car, correct?
I mean, I'm not Avery.
Objection, Your Honor, speculation. This witness cannot know what prompted Ms. Becker to do what, as she was not there when this occurred.
What's your response to the speculation objection?
Once again, because she's such good friends with the defendant and she is a mock trial team member, and an event such as this is such a big, important event, it is rationally based upon the witness's perception.
Response, Your Honor?
Go ahead.
Ms. Perkins was not there, and furthermore, this attorney has not laid the proper foundation for this question, as Ms. Perkins was not at this scene prior to after regionals ended.
I'm going to overrule the objection. The witness may answer if she knows.
Ms. Becker and Mr. Brackman had a big argument after the regional tournament, correct?
From what I heard, yes.
And Avery Becker was kicked off the team for good as a result.
Yes, she was.
Avery Becker tried everything to get back onto this team, right?
Well, I mean, pretty much everything we could think of, yeah.
She tried apologizing to Mr. Brackman.
I mean, mock trial was everything to her, so she definitely apologized.
Because she recognized that what she had done was a mistake.
She did. She felt really, really bad about it.
She also texted everybody on the team asking for help, correct?
Well, I think almost everyone. I wasn't actually physically there when she texted people, so I don't actually know who she texted.
But it is your understanding that she texted Alex Cifuentes for help, correct?
Well, I think she did. Again, I wasn't there, so I don't know.
But despite all of these efforts, Mr. Brackman never let her back onto the team, correct?
No, he did not. You're right.
Now let's talk about the day, March 6th. You claim that you and Avery Becker were together the whole day, right?
Yes, we were together the morning, the afternoon, and into the evening.
You both went to the mall that day, right?
We did.
So neither you nor the defendant Avery Becker was at school on the day of the murder.
No, I mean, we already had first block off and the rest of our classes weren't that important. So, you know, we thought it was okay to go look for a phone, especially because, you know, phones are really expensive and
Thank you. So in conclusion of that statement, was that a yes? Avery Becker was not at school on the day of the murder?
Objection, asked and answered.
Your Honor, the witness didn't answer my question. They started talking about how phones are expensive instead of saying whether or not Avery Becker was at school on the day of the murder.
On those grounds, the objection is overruled. You may answer the question.
So Avery Becker was not at school on the day of the murder, correct?
That is correct.
And nobody in court today besides you can confirm Avery Becker's whereabouts on the day of the murder, correct?
That is true.
And you are Avery Becker's best friend.
Yes, but I don't see what that has to do with anything.
Thank you. No further questions at this time.
Any redirect from the prosecution?
Yes, Your Honor, briefly. Ms. Perkins, Ms. Becker was your best friend, correct?
That is true.
But did this have anything to do with what you did and why you're here testifying today?
Definitely not. I mean, I wouldn't lie for her.
Thank you, Your Honor. No further questions.
All right. Thank you very much. From the defense, do you have another witness?
Yes, Your Honor. The defense calls its next witness, Professor Blake Van Owen, to the stand.
Professor Van Owen?
And Your Honor, before I proceed, may I request a brief time check?
You may.
You have 18 minutes and 35 seconds left.
Wonderful. Thank you.
All right, Ms. Mastrangelo, your witness.
Good morning, Professor. Would you introduce yourself to the jury, please?
Good morning. My name is Professor Blake Van Owen.
And why are you here today?
I'm here today to show that the prosecution's case is faulty and unsound.
Now let's talk about your qualifications. What is your current occupation?
As of now, I work 2 jobs, the first of those being a professor of police practices and social justice up at CU Denver, and I also work as a private investigator.
Now, what does being a private investigator entail?
There are 2 primary pieces that play into my work as a private investigator, those being the analysis and evaluation of investigations and the availment as an expert witness across district and state courts.
Now, do you have any areas you specialize in?
While there are many areas of expertise I have, those most pertinent to today's case would be crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Now, Professor, what is your experience in those fields?
As of now, I have a little over 8 years of experience as a private investigator, consulting on over 100 cases with different cases requiring different areas of expertise.
And now, have you testified in court to these areas of expertise?
As of now, I've testified as an expert in cell tower analysis 5 times, crime scene reconstruction 8 times, and general police investigation tactics 12 times.
And now, Professor, how are you compensated for your time?
My rate is something standard you might find across any expert in the country with my education, my experience, and my job process.
Your Honor, pursuant to Rule 702, testimony by experts, and Rule 703, basis of an expert's opinion, I'm tendering Professor Blake Van Owen as a qualified expert in the fields of crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Ms. Fawn, there are 3 proposed areas of expertise. Do you have an objection to the professor testifying as to any of those 3?
No objection, Your Honor.
Okay. Under Rule of Evidence 702, the professor is qualified as an expert in all 3 categories, and you may resume your examination.
Yes, Your Honor. Now, Professor, did you conduct an evaluation of the prosecution's investigation?
For this case, I conducted an evaluation of reports and evidence from Detective Markowitz and the crime scene reconstruction of Kyle Kuzak.
Now, what stuck out to you during your evaluation?
Throughout my evaluation, there were 3 main issues I took with the case. The first of those would be the lack of evidentiary support for the stabbing method proclaimed by the prosecution.
What's the second?
The second of those issues would be the uncertainty in location with regards to Avery Becker's call detail records.
And Professor Van Owen, what's the third?
Finally, the third issue with reference to the case as a whole, the investigation was methodologically unsound.
Objection, Your Honor. Lack of foundation.
What's the response?
Your Honor, the witness has already testified to an evaluation he conducted in which he looked at the evidence and the crime scene reconstruction of Detective Jordan Markowitz and Kyle Kuzak in this case, so he has laid the foundation for his opinions in this case.
The objection is overruled, and Ms. Fawn, you can cross-examine on these issues during your portion of the examination. Back to you.
Yes, Your Honor. Now, Professor, let's start with the first issue about the stabbing method. Now, what evidence did you review in this area?
In order to analyze a crime scene, the first step I do is take a look at the actual event. So I reviewed crime scene photos, the crime scene reconstruction of Kyle Kuzak in the autopsy report.
And how does your expertise in crime scene reconstruction help you with this evaluation?
Well, throughout this evaluation, I notice any aspects gathered by other people investigating, such as Kyle Kuzak or Markowitz, such as Ring doorbell videos as well, and I use those pieces of evidence to concoct a most likely scenario for the crime.
Right. Now, how did those Ring doorbells you mentioned play into your most likely scenario?
There were 4 Ring doorbell videos depicting an intruder, and that intruder was clearly of smaller stature relative to Mr. Brackman himself.
And what is the significance of this?
The prosecution, their general idea is that the intruder was coming into the house while Mr. Brackman was alerted to their presence. And Mr. Brackman, this larger man, approached with a knife in hand, and the smaller intruder somehow grappled the knife away and inserted it with lethal force, which is simply unlikely considering the size of the intruder.
Now, did you review any other evidence?
I reviewed the autopsy report and crime scene photos.
And what did the autopsy report show you?
The autopsy report details the force of the blade in a downward direction toward the
Objection,
thoracic.
Your Honor. Hearsay. The autopsy report is an out-of-court statement being offered for the truth of the matter. Simply the fact that Professor Van Owen reviewed it does not mean that it is not hearsay.
What's your response?
Your Honor, pursuant to Rule 703, this objection is admissible as, in a basis of an expert's opinion, they are allowed to look at any evidence throughout this case, as well as witnesses' affidavits. So Professor Blake Van Owen has personal knowledge to this autopsy report, and therefore it is admissible under hearsay.
Under those grounds and reviewing the rules of evidence, the objection is overruled. You may resume your question.
Yes, Your Honor. Professor, would you please continue about the autopsy report?
Of course. As I was saying, that knife had a force downward and toward the thoracic aorta, which would indicate that the smaller intruder was standing above Mr. Brackman and inserted the knife into that upper scapula.
Now, what is your most likely scenario with the stabbing method?
The most likely scenario in this case, in my expert opinion, contradicts the prosecution scenario, as the evidence points to a smaller intruder bringing a knife in and stabbing Mr. Brackman in order to attain that actual lethal force and direction of stab.
Now, let's move on to the second issue you mentioned, the inaccuracy of the cell tower diagrams. Now, did you review these yourself?
Yes, I reviewed all exhibits in this case, including the cell tower information.
Ms. Karras, would you please screen share Exhibit 16 as it has already been admitted? Thank you. Now, Professor, what did you notice during your review of this diagram?
The very first thing I noticed were those 3 different sectors activated by Ms. Becker's cell phone within the time frame gathered.
And what do these sectors show you?
Well, you see, this is another instance where the prosecution claims something that just isn't true. They claim that the location of Ms. Becker is pinpointed by these diagrams. However, that red area you see there is an area encompassing 38 square miles. Now, this is no small area. And what this means is that Ms. Becker was within 38 square miles of Mr. Brackman's house, which is not a pinpointed location in the slightest.
And now, could these cell tower diagrams accurately pinpoint anyone's location?
Unfortunately, all they can do is pinpoint somebody within that 38 square mile radius, which is not even close to put someone at a physical location during a crime.
Now, Ms. Karras, would you please stop screen sharing? Thank you. Now, Professor, let's talk about the last issue, that the investigation was methodologically unsound. Now, what made it unsound?
There were, again, a few pieces that played into this conclusion, being the first of those, the lack of evidence gathered on behalf of Detective Markowitz.
What evidence did Detective Markowitz fail to gather?
There were a lot of pieces of evidence with regards to cell phones that Detective Markowitz could have and should have gathered in this case.
Now, what evidence would that be?
The first of those, and arguably the most important, would be the cell phone information in the text messages from Alex Cifuentes.
Why is it important that Detective Markowitz should have investigated the text messages?
Well, in my expert opinion, as an expert in general police investigation practices, you need to investigate every angle and have the most solid and valid piece of evidence to make your conclusions. Now, Detective Markowitz had the tools literally at her fingertips to gather the information from Ms. Cifuentes' phone through Cellbrite. She has testified to her understanding of this technology, yet in a murder investigation, for some reason, that technology was not used.
Now, did Detective Markowitz fail to gather any other evidence?
Keeping on this track of cell phone information, some call detail records and information from Mr. Brackman's phone could have been gathered.
What information would that have been?
The two primary pieces would be the production of records request from Ring, the company itself, which would show us actually if Mr. Brackman received notifications and thus was alerted by the Ring doorbell system. And the second would be any other information regarding Mr. Brackman's life.
Now let's talk about that Ring doorbell notification. If we had known about the notifications, what would that show us in this case?
There are many things it would show us. In my expert opinion, it would first show us whether or not Mr. Brackman was alerted to the intruder upon their entry. And secondly, it would show us whether or not Mr. Brackman was with his phone, whether or not Mr. Brackman was prepared, and thus whether or not Mr. Brackman engaged with the intruder.
Now, Professor, did the prosecution investigate any other suspects?
Unfortunately, they did not.
Did you investigate any other suspects?
While the prosecution noted another suspect, I took a look into them being Blair Rollins.
Who is Blair Rollins?
Blair Rollins is the child of a Jonathan Rollins, a former client of Mr. Brackman's who is now serving a life sentence in prison.
What is the significance of that?
The significance is that Blair Rollins presents a clear motive against Mr. Brackman that was not investigated.
Now, Professor, do you have an expert opinion in this case?
There are a few, yes.
And Professor Van Owen, what are those expert opinions?
Primarily, my expert opinion in this case is that the prosecution and their individual personas lacked the initiative to gather required evidence and information to truly pin a crime on someone.
And what would we have known if they had investigated more?
All that I know as an expert across the fields pertinent to this case is that it was a bit rushed. And when you are rushed, you simply miss things. They missed things that were police work 101. You heard from Markowitz and Kuzak themselves. You have to investigate every angle, unlikely or likely. However, even noting a quote unquote unlikely angle in Blair Rollins, it was not investigated by Markowitz. Even noting the unlikely angle that Miss Becker and Miss Perkins were not present and with Miss Becker's phone, it was not investigated. And simply put, when you investigate a crime, especially a murder, you need to consider every aspect in order to have a clear case.
Thank you, Your Honor. No further questions at this time.
Cross-examination.
Yes, Your Honor. Good morning, Professor Van Owen. First, I would like to talk about some of your conclusions. Now, Mr. Brackman was killed before 2:20 in the afternoon.
As we know from the autopsy report, roughly, yes.
On a weekday.
Yes, a Friday.
It's reasonable to assume that people are at work in the middle of the day on a weekday.
Perhaps, although it is a Friday, so some people take Fridays off.
It's reasonable that an intruder could assume people are at work in the middle of the day on a weekday.
Objection, Your Honor. Question calls for speculation.
What's your response to the speculation of objection?
Your Honor, whether or not an intruder would assume that someone's at home or at work during the time of the crime directly relates to Professor Van Owen's expertise as a crime scene reconstructor and in general police investigation. It's extraordinarily pertinent to his conclusions.
Response, Your Honor?
Yeah, go ahead.
Your Honor, counsel is trying to have the witness speculate as to the state of mind or the thought process of the intruder, which does call for speculation. And that would not be in his expertise of crime scene reconstruction as it is personal thought of an intruder.
Okay, and I'm going to overrule the objection. Professor, answer the question for what you know.
Professor, go ahead.
Were I to be a person that has a reasonable thought process, I would assume that most people who have a job and are employed would thus be at their place of employment during a weekday.
And yet, even considering that reasonable assumption, your theory is that Blair Rollins decided to come to kill Mr. Brackman in the middle of the day on a weekday.
Unfortunately, my theory is not that Blair Rollins committed the crime, but rather that the evidence presented does not pin the crime on anyone. It's simply not enough evidence to accurately make a conclusion.
And now Mr. Brackman was sitting alone in his home.
Yes.
He could have been alerted to the presence of the intruder when they were entering the home.
Based on the
Objection, Your
ring,
Honor. Counsel is testifying. If they would like to rephrase their questions as questions, that would be great.
I'm actually going to overrule that objection. That's an appropriate question as posed.
Yes, Your Honor.
as I was
Professor,
saying, he could have been alerted to the intruder's presence from the Ring doorbell system. However, upon reviewing of the videos, it's clear the intruder, upon entry in the back door, was not met with someone considering their lackadaisical and slow movement upon entry.
but my question was if he could have been alerted by the noise that the intruder made when they were entering the home.
While it's possible, modern sliding glass doors are incredibly quiet for consumer benefit.
And yet you're saying that Mr. Brackman didn't hear the intruder break into the home at all.
Considering the evidence presented in this case and the way the intruder actually walked into that back door, it's fairly clear that Mr. Brackman was not alerted to their presence.
And you would have to stand immediately behind Mr. Brackman to stab him from directly behind, correct?
I would definitely say so.
And your theory is that the intruder was quiet enough to break into the home, sneak up just behind Mr. Brackman, and Mr. Brackman wasn't notified at all?
My theory is that is much more likely considering the approximate size of the intruder and the fact that they would not have come out of a struggle on top.
Is that a yes? Your theory is that the intruder was quiet enough to break into the home, walk up right behind Mr. Brackman, and have him not be notified at all?
That is a more likely alternative theory, yes.
Professor Van Owen, you have a cell phone, correct?
I do. I have this Huawei P40 Pro, which is this wonderful piece from the east side of Asia.
And you have contacts in this cell phone.
I do have a couple.
And when you receive a text from a contact, you don't typically have reason to question the sender.
It certainly depends on the context of the text. However, it is very accessible and it's very common for people to spoof the sender of a text or a call in order to create a different appearance.
But still, it's reasonable to assume upon receiving a text from a saved contact that it is in fact from that contact.
Were the text to be consistent with that contact's personality, it would be reasonable to assume that.
Now I would like to move on to your theories regarding cause of death. Your Honor, let the record reflect that I am showing the witness what has previously been marked as Exhibit 21.
It shall.
Professor Van Owen, you're familiar with this photo, correct?
Yes, this is my photo.
This is a photo of an orientation in which you can hold the knife.
Yes, that's true.
You relied on this photo when reaching your conclusions about this case.
Not necessarily, considering I prepared this photo myself. It was more as an explanation for those that didn't understand the vernacular I used in my report.
You prepared this photo yourself, correct?
I did, yes.
Your Honor, I move to enter Exhibit 21 into evidence.
Any objection to the admission of 21?
No objection, Your Honor.
It shall be admitted.
This photo is how you believe it is more likely that the perpetrator was holding the knife, correct?
Considering the form and style of the stabbing, this would be the most comfortable way to achieve that angle.
Your Honor, let the record reflect that I am also showing the witness what has previously been entered into evidence as Exhibit 4.
It shall.
Professor Van Owen, this wound on the right is horizontal, correct?
The laceration in the shirt certainly appears to be.
Is that a yes? This wound appears horizontal?
From this picture, the wound appears horizontal when in reality it's not.
From this picture of the decedent, the wound appears horizontal, correct?
Objection, Your Honor. Asked and answered. The witness has answered this question.
What's your response?
Your Honor, the witness has not actually answered the question that I am asking of whether this photo does seem to be a horizontal wound.
The objection is overruled. The witness may answer the question.
The photo
Go ahead.
While the photo depicts what appears to be a horizontal wound, the autopsy details that it was in fact in a vertical orientation.
And you reviewed all the physical evidence, correct?
Yes,
You reviewed this photo of the body, correct?
in addition to the other few, yes.
And now your conclusion, as seen in Exhibit 20, is that this knife was held pointing down vertically.
My conclusion is yes, that the knife was vertical in conjunction with the autopsy report.
Even after reviewing this photo of a horizontal wound, you still came to the conclusion that it was a vertical orientation.
Certainly. If you were to read the autopsy report, you would notice that through microscopic examination and digital exploration, the anterior side of that laceration into Mr. Brackman's scapula was markedly smoother than the posterior side, which would indicate that the knife blade was facing the anterior side of Mr. Brackman upon entry and thus was pointing toward his front.
Is that a yes, Professor Van Owen? Even reviewing all this physical evidence, including this photo of a horizontal wound, you still came to the conclusion of a vertical orientation?
More accurately, the medical examiner conducting the autopsy came to that conclusion. I simply agreed with them.
Thank you, Your Honor. No further questions.
Any redirect examination?
No redirect necessary, Your Honor.
All right. Thank you very much. Defense, you may call your next witness.
Yes, Your Honor. Though before the defense proceeds, Your Honor, I'd like to request a brief time check.
You have 7 minutes and 55 seconds left.
Thank you.
All right. Ms. Tusek, who's your next witness?
Your Honor, the defense calls their third and final witness, Avery Becker, to the stand.
Ms. Becker? I want to remind you, you are under oath. Ms. Tusek, your witness.
Thank you, Your Honor. Good morning, Ms. Becker. Would you please introduce yourself to the jury?
Good morning. My name is Avery Becker.
Ms. Becker, why are you here today?
I shouldn't be here at all, actually. They're accusing me of things that I would never in my wildest dreams do, and the very thought of them makes me sick to my stomach.
Okay, thank you. I'd like to move on and talk a little bit about your high school experience. What high school did you go to?
I went to Colorado High School. We called it CHS.
Did you participate in any extracurricular activities there?
I was in mock trial for 4 years and I loved it.
Why did you decide to do mock trial?
Well, it sounded really fun at first when I was a freshman, and after I started doing it, I just realized that I was pretty good at it and I loved it and I wanted to do it for the rest of high school.
And who was your mock trial coach?
Coach Brackman.
Would you mind describing to the jury a little bit about what your relationship with Mr. Brackman looked like?
I knew Coach Brackman for 4 years. That's a really long time to know someone, and I looked up to him for a long time. And we were both really competitive. We really wanted to win. We did start to argue in my senior year, though.
Okay. Now let's move on and talk about the events that took place after your final regional competition. Would you mind describing to the jury the practice after your final regional competition in mock trial?
I had just won an award for best attorney at regionals, and I was really excited. And I hoped Coach Brackman would be excited too, because it was good for the team. Unfortunately, we did end up having an argument over work ethic, which happened quite a bit.
And how did this argument make you feel?
Personally, I felt...
It will.
Thank you, Your Honor. Permission to proceed, Your Honor.
Let me just try to get that live streaming back up.
Yes, Your Honor.
Your Honor, my screen says that it is currently streaming now.
All right, I got it back up. Sorry about the interruption, and the time will not, that we were troubleshooting, will not count against you.
Thank you, Your Honor. Permission to proceed now?
Go ahead.
Thank you.
You may.
Now, Ms. Becker, how did Mr. Brackman react when he saw his car?
Oh, he was just horrified, and so was I. It was just really a bad situation.
Did you know that the marker you had used was permanent?
No, I had no idea. I thought it was a dry erase marker and it would just wipe right off, which doesn't excuse what I did, but I did not think that any lasting damage would be done to his car.
Did you do anything to try and make amends with Mr. Brackman?
I did everything I thought I could. I texted Coach Brackman. I I offered to pay for the damages I had done. I offered to like hand scrub it off of his car and see if that would work. I even went to his law firm to see if he would talk to me, but I never reached him. And then all of a sudden he was just gone.
Okay, thank you. Now I'd like to move on to the events that took place on March 5th. What did you do after school that day?
I went to the fry shack with my best friend Taylor to just blow off some steam after school.
Did you recognize anyone else there that you knew?
I recognized a lot of people. It's a pretty popular place for a lot of the people in mock trial, so I knew a lot of them, and I definitely saw Alex Cifuentes there.
How long did you and Miss Perkins stay at the fry shack?
We didn't stay long after we saw Alex. I set down my phone, I went to the bathroom, and then Taylor and I went to the mall.
How long were you and Miss Perkins at the mall?
We didn't stay for that long. I think like we walked around, we did a little bit of shopping, and then we just got tired, so we went home.
Okay. Now let's move on to the events that took place on March 6th, the day after. What happened on the morning of March 6th?
Well, I woke up and I just, for the life of me, couldn't find my phone anywhere, and I was freaking out because I couldn't afford to get a new phone. So I went to Taylor's house to ask her if she'd help me look for it.
And did she?
Yeah, Taylor's always been such a great friend. She was happy to help me. So we skipped school for the day to look for it.
And how long did you and Miss Perkins look for your phone?
We looked for my phone all day. I was pretty frantic because, you know, I really like my phone. I like having it with me. So from morning until night, we were just looking frantically all over town.
Were you ever able to find it?
No, I don't know what happened to it. This is not like me to completely lose my phone. And Taylor even tried calling it and it just went straight to voicemail, like it was stolen or lost, or not lost, I'm sorry, dead. I just don't know what happened to it.
Okay. Now I'd like to move on and talk a little bit about your relationships with other students. Now, you mentioned Alex Cifuentes earlier. Would you mind describing to the jury what your relationship with Alex Cifuentes looked like?
Alex and I never really got along. We weren't enemies or anything. I just kind of always got the feeling that he didn't like me very much.
Did you talk to Mr. Cifuentes very often?
No, in fact, I can't remember the last time I talked to Alex outside of mock trial.
Now, Mr. Cifuentes claims to have received text messages from you. Did you send Mr. Cifuentes text messages?
No, and I can't remember the last time I ever even texted Alex.
Now, did you notice anyone that Mr. Cifuentes hung out with?
Well, this is just based on what I've seen because I haven't spent a lot of time with Alex, but from what I've seen, he spent quite a bit of time with Blair Rollins.
Do you know who Blair Rollins is?
I think that everyone at CHS does. Blair was pretty well known because his dad went to prison for life and Coach Brackman was his attorney.
And do you know where Blair Rollins is now?
I don't think anyone does. He disappeared right after graduation.
Okay. Now I have one final question for you, Ms. Becker. Were you anywhere near Mr. Brackman's house on March 6th?
No, and I don't understand why I'm here. I wasn't anywhere near Coach Brackman's house, and then he was just gone, and the person who did it is still out there while I'm sitting here.
Thank you, Ms. Becker. No further questions at this time, Your Honor.
All right, cross-examination.
Yes, Your Honor. Hi, Ms. Becker. I'd like to start off by talking a little bit about mock trial. You did mock trial at Colorado High School, correct?
I did. I loved it.
And you were actually quite successful on that team, weren't you?
I was really good at playing an attorney, yes.
You even got lead attorney roles on your mock trial team, correct?
Yes, I was really good at playing an attorney.
But despite your success on your team, your mock trial coach, Mr. Brackman, constantly criticized you, didn't he?
We did have a lot of differences of opinions just about how to prepare for competitions because we both really wanted to win.
In fact, he called you lazy and unprepared. Isn't that right?
He did,
Objection,
yes.
Your Honor, hearsay.
It's a response to the hearsay objection.
This statement is not being offered for the truth of the matter asserted, but rather for the effect on the listener.
On those grounds, I'm going to overrule the objection. You may answer the question.
So Mr. Brackman did call you lazy and unprepared, correct?
He did, yes.
At one point, he even demoted you to the B team, didn't he?
Yes, we'd been arguing quite a bit, and at that point, he demoted me, yes.
Now, I'd like to talk about the regional tournament. You competed with the A team at the regional tournament in 2020, correct?
I did, yes, and I won a Best Attorney Award, which I was super excited about.
And a Best Closing Award, correct?
I believe I did, yes.
So you really did quite well at that tournament.
Yes, I felt that I was pretty good at playing an attorney in mock trial.
Despite your success at that tournament, your coach actually berated you for your performance afterwards, didn't he?
Well, I really did hope that he would be excited because I thought it was something good for the whole team, but we did end up arguing.
He wasn't excited, was he?
Not that I could tell.
In fact, he chewed you out in front of your entire team.
We did have an argument in the middle of practice, yes.
And you were understandably pretty upset by that, weren't you?
I was upset, yes.
So let's walk through what happened then. You were standing there being criticized and embarrassed by Mr. Brackman, correct?
Objection, Your Honor. Testifying for the witness.
What's the response to the objection of testifying for the witness?
Your Honor, these are facts that have been entered into evidence. I'm merely using this as a foundational question for my line of questioning.
On those grounds, the objection is overruled.
So it is true that you were standing in the middle of that room being embarrassed and criticized, correct?
I mean, I was a little bit embarrassed. It's hard to argue with your coach, you know?
Yeah, so instead of arguing with him, what you decided to do was go outside. You wanted to get some fresh air, right?
Yeah, I just needed to get out of that situation. It was just so hard to be in.
And then once you were outside, you actually realized that you were holding a marker, didn't you?
Yes, I'd been up at the board before Coach Brackman and I had our argument, and I still had the marker in my hand.
And when you were holding that marker, you had an idea that you thought would really show Mr. Brackman how angry you were. Isn't that right?
Objection, Your Honor. This is testifying for the witness. This has not been entered into evidence yet.
Okay, and what rule of evidence are you citing?
Your Honor, it is not, Ms. Becker has not testified to how she felt and her motive behind writing on Mr. Brackman's car. Therefore, a question cannot be asked directly relating to that.
So the objection is facts, not in evidence?
Yes, Your Honor.
Okay, what's your response to that objection?
Yes, Your Honor. First and foremost, the door has been opened as to her motive, her mindset at this given time. Additionally, this question is being asked to enter the fact into evidence. Again, a fact is not in evidence until it is in evidence.
On those grounds, I'm going to overrule the objection. You may ask the question.
So, Ms. Becker, when you were standing there, you had an idea that you thought would show Mr. Brackman how you really felt. Isn't that right?
Honestly, I don't know what I was thinking in that moment. I was just really upset and frustrated by the whole situation, and I didn't think I'd do any lasting damage.
But to be fair, you then did actually vandalize his car. You wrote Worst Attorney Award across it, correct?
I did, and when I found out the marker was permanent, I was just so horrified at what I had done and how much farther I had taken it than I meant to.
But actually, when you were looking at that car, what you were thinking was that you had done something that would show Mr. Brackman how you really felt. Isn't that right?
I was so upset, and like I said, I didn't feel like I was being listened to. So for a moment, yes, I did think that when I still thought it would wipe right off, that maybe he would just finally understand my frustration.
So that's a yes. You thought it would show him how you felt.
Until I found out it was permanent, yes.
Then after this situation, you went home, didn't you?
Yeah, I was just so upset and I had to talk to my mom.
And you did talk to your mom, correct?
I did, yeah, my mom's great.
And when you were talking to your mom about this incident, you told her that you would get back at Mr. Brackman if it was the last thing you did. Is that correct?
You know, I was so upset. I was crying and I just couldn't believe that everything I'd worked so hard for seemed to be falling apart. But right after I said that, I realized how stupid it sounded, and my mom calmed me down, and the intent was completely lost after that.
But in that moment, what you said was that you would show you would get back at Mr. Brackman if it was the last thing you did, correct?
I did, but I could never imagine someone taking it this far. I can't even believe I'm sitting here.
So that's a yes to my question.
I did say that, but I would never have done this.
No further questions, Your Honor.
Any redirect?
No redirect necessary, Your Honor.
All right, may this witness be excused.
Your Honor, the witness may be excused, but before the defense rests, I'd like to confirm that exhibits 1, 2, and 6 were entered into evidence by the defense.
They were.
Thank you, Your Honor. Then the defense rests.
All right. At this time, we are ready for closing arguments. Rebuttal has properly been reserved by the prosecution, and any time that they do not use during their initial closing argument may be used in rebuttal, and the rebuttal should focus on arguments, responding to arguments made by the defense. Prosecution, are you ready?
Yes, Your Honor, the prosecution is ready to proceed with closing arguments.
You may begin.
Avery Becker was telling the truth. When Avery Becker said, "I'm going to wait until Mr. Brackman is at work, then break in and trash his house," she was telling the truth. How do we know that Miss Becker was telling the truth? It's not because that's what she told us on the stand today. In fact, she tried to tell us exactly the opposite, but because all of the evidence in this case leads to that conclusion. To start, we know that the defendant was angry. Angry enough at her coach to vandalize his car because she knew that that would show him how she felt. She told us that today. She knew that would show him. And angry enough to vandalize her coach's house because she knew that would show him. She told us that in Exhibit 14. So, on March 6th, 2020, Avery Becker bought a Halloween face mask, grabbed her best friend, Taylor Perkins, and headed to Mr. Brackman's house. As you can see in Exhibit 16, Miss Becker left her own home, drove along the dotted line to Mr. Brackman's house, and arrived at his front door. Here is that video of Miss Becker. A teenager in broad daylight in a crazy mask, mocking her mock trial coach. This is not a person headed to kill someone in cold blood. This is a high school kid causing trouble by trashing a home. So, Avery Becker is being charged with burglary. And she's being charged with felony murder. Felony murder means that the defendant attempted burglary, and as a result, someone died. In other words, as Ms. Becker put it, she went to trash Mr. Brackman's house, and in the course of that bungled attempt, Mr. Brackman lost his life. On that day, Mr. Brackman was enjoying a calm afternoon in his own home. He was about to head out for the mock trial practice scheduled for that afternoon when he got a notification that there was someone at his house. Then, as both Detective Markowitz and Ms. Kuzak explained, the evidence of this case builds a story for us. First, Mr. Brackman realized that there was an intruder and grabbed a knife from his kitchen. Then the two became engaged in a struggle where they knocked this plate off a table. The altercation ended with Miss Becker stabbing Mr. Brackman, puncturing his heart and causing him to bleed out. When Mr. Brackman pulled that knife out of his body after the defendant ran away, he fell to the floor and he died in the middle of his own home. That is why Avery Becker is being charged with first-degree felony murder. We, the prosecution, held the burden of proof in today's case. We had to prove each element of the crimes charged to you beyond a reasonable doubt. That is, a doubt that would make a reasonable person hesitate in matters of importance to themselves. As jury instruction 9 provides, the first thing that we had to prove was that the defendant had intent to commit criminal mischief. We proved this with Exhibit 14, where the defendant says herself her plan to trash Mr. Brackman's house. That was her intent. The second thing that we had to prove, if you look at jury instruction 8, is that the defendant committed second-degree burglary. We proved this with cell tower records and video clips that prove that Miss Becker was at Mr. Brackman's house in the time frame of the burglary. And And finally, we had to prove to you that Ms. Becker killed Mr. Brackman. We proved that to you with a video of Mr. Brackman lying dead in the middle of his own home, stabbed to death. When you consider the evidence in this case, we ask you to recognize that the defendant was telling the truth when she said she was going to wait until Mr. Brackman was at work, then break in and trash his house. And see how the rest of the story falls into place. We ask you to submit a verdict of guilty.
Thank you, Ms. Leland. Ms. Tusek, are you prepared for your cross-exam or closing argument?
Yes, Your Honor. May it please the court?
Go
Your
ahead.
Honor, members of the jury, the evidence and testimony you heard today proves that the prosecution's case is based on sloppy investigations, tunnel vision, and a desire for a convenient conclusion. In turn, this conclusion is erroneous and incorrect. Now, this is no simple case about a parking ticket. This is a murder trial, the result of which could lead to a young, innocent woman going to jail for a crime she did not commit. The prosecution made 2 charges against Avery Becker. Count 1, murder in the first degree, and count 2, second-degree burglary of a dwelling. The prosecution bears the burden of proof. They are obligated to prove every single element of the crimes charged beyond a reasonable doubt. This means that if you, the jury, have reasonable doubt regarding any of the elements, the prosecution has failed to meet their burden. In turn, Ms. Becker must be found not guilty. The prosecution called 3 witnesses to the stand in an attempt to prove all the elements of the crimes. The prosecution called Jordan Markowitz, the homicide detective who testified today that part of her job includes looking into other possibilities. However, Detective Markowitz failed to look into the possibility of a disgruntled ex-client of Mr. Brackman's as a viable suspect. Instead, Detective Markowitz followed the investigation where she wanted it to go, for the sake of convenience. In contrast, the defense called Professor Blake Van Owen. Professor Van Owen was able to rationally disprove Detective Markowitz's conclusions on multiple aspects of her investigation. These would include things like the stabbing method and the fact that the cell tower analysis didn't pinpoint Ms. Becker's location on March 6th with absolute certainty. In fact, all the cell tower data showed was that Avery Becker was somewhere within 38 square miles of the crime scene. Professor Van Owen's job is to analyze investigations made by others. And in his expert opinion, Professor Van Owen was able to come to the conclusion that the foundation of the prosecution's case is methodologically unsound. The prosecution also called Kyle Kuzak, a crime scene reconstruction investigator. Ms. Kuzak noted several components in her investigation that could call for a different conclusion, but chose not to follow any of them. This is a recurring theme on the prosecution. Ms. Kuzak's so-called thorough investigation overlooked an alternative suspect. This thorough investigation glossed over vital observations like a wedding ring on Mr. Brackman's hand. While it may be true, Ms. Kuzak thinks her investigation is thorough, what she thinks doesn't make something a fact. Here's what the facts actually show. 1, the facts show Avery Becker couldn't have been anywhere near Mr. Brackman's house the day of the alleged crime, not only because she was with Taylor Perkins all day, but because she didn't even know where Mr. Brackman lived. 2, the facts show Blair Rollins as a reasonable and viable suspect in this case. Blair Rollins is the perfect example of the disgruntled ex-client Detective Markowitz had mentioned, yet failed to look into. The prosecution also called Alex Cifuentes to the stand, another member of mock trial. Now, as passionate as Mr. Cifuentes was, he never received as many awards in mock trial as Ms. Becker. This was the perfect nesting ground for jealousy, which, as we know, is a powerful and dangerous emotion. Now, Mr. Cifuentes can testify to how Avery Becker participated in mock trial, but Taylor Perkins can testify to exactly where Avery Becker was on the day of March 6th, as the two were together the whole day in search of a missing phone that was never found. The facts and evidence in this case all go to prove that the prosecution tried and failed to justify their sloppy and rushed investigation. The facts and evidence all go to prove that the prosecution favored convenience over justice. It has been shown time and time again throughout today's trial how the prosecution's carelessness led them to the convenient conclusion that put Ms. Becker on stand today. The prosecution tried to justify their investigation. However, it doesn't change the fact that they overlooked a prime suspect with clear motive. Following leads to identify other potential suspects is police work 101. What happens if you miss police work 101? You risk putting the wrong person, an innocent person, in jail, potentially for the rest of her life. The prosecution failed to meet their burden, and because of this, the defense asks you to find Avery Becker not guilty. Thank you.
Thank you, Ms. Tusek. Ms. Leland, do you wish to respond in rebuttal?
Yes, Your Honor. I believe I have 40 seconds remaining.
That's what I saw on the clock.
Yeah. The experts in this case told you that they investigated all of the evidence. It just so happens that all of that evidence led to Miss Avery Becker. They told you that they considered the fact that Blair Rollins might be involved, but that instead all of the evidence pointed to Miss Avery Becker killing Mr. Brackman. Text messages, cell detail records, cell phone records, maps, pictures of broken plates and bodies, everything led to Avery Becker committing this crime. Find Avery Becker guilty.
All right, thank you very much. And that concludes the trial. For the participants, I know I'm not supposed to say much in critique, and I don't plan to, but there's one comment I want to make to all parties. First is, I think everybody was tremendously well prepared for the presentation, and I'm very impressed by what I saw today. So I hope you were all pleased with yourself. And the reason it went well is because you were well prepared. So that's the one. That's the thing that I hope you keep in mind going forward is your preparation showed. You really anticipated each other's some expected objections and were ready for the responses, and were thinking pretty quickly on your feet. So that was also something I was impressed by. The one comment I want to make from somebody who's been doing this for a long time is when you ask a witness a question on cross-examination, you're hoping for a yes or no answer. And the witness tries to embellish by adding a few other things. And then you try to stop them by saying non-responsive. One thing you should consider doing is asking the judge to strike everything that came after the yes or no answer. Because even though the jury will have heard it, you're still part of what you're doing is making a little bit of a show about the fact that the witness is trying to get in things after a yes or after a no. So consider and consult with your coaches on this because they're coaching you through this. But consider after you say witness is not responsive, judge, will you strike everything after the yes or after the no? The second thing I want you to warn you about when you do that is normally you're going to have a jury sitting right there, and the jury is going to see that the witness wants to say more things. And depending on the trial, you might have the judge say, the witness can answer the question. And even though you ask them a yes or no question, and they say yes, but, you may often get a judge just letting them answer the question. And then the other thing that can happen is they're going to say yes, but the judge agrees with you that it's non-responsive, strikes the rest of the answer. And then when it comes back to the other side, usually the prosecution gets to say, you were trying to answer the question more thoroughly and the defense was trying to keep the jury from hearing the rest of the answer. What is it you wanted to tell the jury? So you can use a little flourish in the redirect examination and recalling the moment where whoever was doing the cross-examination cut off the witness. And then when you come back to redirect examination, you get to add this little show to the jury and say, oh, they were trying to prevent you from hearing this what you wanted to say, what is it that you wanted to say? And because now when you're redirecting, you can put all of those questions that they got cut off on during cross-examination back in front of the jury. And it makes it seem like you're the ones who really want to bring all the truth out. And the person cross-examining was trying to keep that away from the jury. So those are just some things I want you to keep in mind when it comes to cross-examining and cutting off witnesses. Other than that, I don't think there's anything else that we need to do. Whomever is doing the scoring or the regional host, is there anything else we have to do or should do?
Judge?
Yes.
This is Charlie White. I'm one of the scoring panelists. I'm also, for total transparency, I'm a member of the state mock trial committee. Would you give, why the other scoring panelists critique, can you give Kyle a phone call and talk about an issue that's come up?
You want me to give the?
Would you call Kyle right now? Yeah, we have an issue that he'll talk to you about.
Oh, while we're on the record?
Yeah, if you can, because it impacts on what I'm doing.
Okay, hold on.
Sorry about that. Maybe while he's doing that, I forgot who other scoring panelists are. If you want to comment briefly, so we give you guys feedback.
Sure. Oh, sorry. If someone else wants to go first. Nope. All right, I'll go. My name's Brett Landis. I am the managing attorney of our local Colorado Legal Services office. Really, really wonderfully impressed by all of you. I thought a particular strength from both teams was your objections and your responses to the objections. I thought it showed a really good handle of evidence and a really, really good willingness to engage in the process of making those evidentiary objections. So really kudos all around on that. With the one exhibit that was an older version of that, I thought that was handled really well. And I especially want to thank the defense for your professionalism in bringing up that it was a different exhibit, and the prosecution, your professionalism in acknowledging that right away. So really well handled by both sides, and really appreciated that. I think there were some of the questioning that was really excellent in this round. And you were really well-matched teams, I thought. I do want to just highlight Ms. Leland's closing because that was really, really excellent. The thought and the good use of the technology to show the exhibits as you were talking about them was a really, really good way to demonstrate your case. And I thought it was very persuasive. Both teams, I think each had an expert who was really effective. Kuzak for the prosecution, and then the only expert for the defense.
You got it.
I think both of those expert witnesses handled cross really well. Your testimony was more believable because of how well you handled.
I was told that we need to wrap up the session because we've run late. And Charlie, I just posted my phone number to you. If you could give me a call as soon as we close the session. And
how'd you get me your phone number?
What's that?
How did you get me your phone number?
Oh, I just sent it to you privately in the chat.
Oh, hang on, let me look there.
You got it. And I'm sorry to cut you off, Ms. Landis, but I was told we're running late and we need to move things along.
No, that's okay. My screen froze, so I was done.
All right. Yeah, it's a great job. I've been doing this for many, many years, and I can tell you this is probably the most closely matched team that I've ever judged. But so great job to everybody.
Wonderful. Well, thank you very much, everyone, and good luck in the competition. And Charlie, did you get my phone number? Great.
Thank you so much.
Thank you.
Thank you, Your Honor.